Hello. Hello, Courtmaster sir. Hello, Courtmaster sir.
Any mentioning in the original side?
Yes, my lords, leave to mention, my lord, once minor correction in the cost title in the order sheet. My lord, I've indicated if it can.
This matter is original.
My lord, I've already, yes. In the pencil, my lord, I have just one. Yes.
This matter dates back to 2011. Honorable 8th Chief Justice has heard this matter, and whoever heard it, and either elevated to Supreme Court or transferred to other court. So this matter is last order was that it was fixed on 20th April. Hearing matter. Regarding the accreditation card of the journalist on the ground of discrimination, and that was challenged.
All right, we'll see. We'll include it.
Yeah.
Yes,
My lord, may I take leave to file appeal, my lord?
without certificate,
My lord, facts of the case is, my lord, appeal and
without certificate copy.
without certificate copy.
May I have a lordship kindly to mention one matter for upgradation from the monthly list, my lord. Police protection matter as per the Honorable Supreme Court's direction, my lord. Suddenly,
You Let us see how to upgrade everything, we don't know. Anyway,
But may I permitted to mention one matter. This is regarding the disruption of medical services in the government hospital and medical colleges,
it's a public interest litigation.
public interest
Original
litigation.
site matter.
No, the appellate side matter. It is,
Monday, can you mention?
some precedents may be given.
Monday, you please mention.
Yes.
appeal without certified.
Yes.
But may I permit to mention one urgent malad public interest litigation pertains to malad the panchayat election malad here malad the list of malad the presiding officer and polling officer has been intentionally circulated in the WhatsApp group malad disclosing our details malad the we are apprehending malad.
You give the slip.
Malad, I'm just filing malad.
Permitted to mention to file the appeal without certified copy.
My lord, mentioning for leave to file this appeal because
Without
Lordship.
certificate copy.
yes, lord.
Without certificate copy.
Without certificate copy.
Yes.
My lord, praying to file the memorandum of appeal without the certified copy. My lord, one small indulgence. What happened was when the writ petition was filed, there were certain annexures where the filing section said that it is not visible. Kindly take my lord's leave. My lord, the honorable bench that time gave us leave. We are assuming that since we have filed the appeal, again the annexures were attached and it will not be allowed, my lord, if my lord's leave is not being.
All right. But how will we read if it is not legible?
My lord, it is very much visible. I don't know why they are being.
All right. If it is not visible, we will ask you to.
If my lords kindly have a.
File.
My lord, I'm tendering my apology
Apply.
for mentioning, my lord. I had taken a leave for this matter on Friday, my lord. This matter was listed, my lord, yesterday also as item number 25. This matter relates to, my lord, several candidates, my lord, were prevented from finding their
It is
nomination.
there the list today.
No, my lord.
It will come tomorrow.
It was there, item number 25, the nominations, there were 2 persons were killed, my lord, but my lord would
Yes,
kindly consider.
we read in the newspapers. We'll do something. Yes, please call the list.
Original side daily list, item number 1.
Please, my lord.
My
lord, I
in this matter.
Yes, sir.
My lord, I appear virtually. Am I audible, my lord?
Yes, yes, sir. You are audible.
My lord, this is a writ appeal seeking to challenge the order passed by the learned single judge upholding the initiation of proceedings under section 148 of the Income Tax Act for the assessment year 2019-20. Now, my lord, the genesis of this is I received a notice under section 148A, which is at page 88. My lord, just see that notice for a moment. Sorry, it starts at page 82, my lord. The assessing officer refers to some information that has been disseminated, uploaded in the case of the assessee Shri Kalicharan Agarwal for the assessment year 1920 in the Insight portal under the category of high risk cases. Then certain information was gathered by the Office of Deputy Director, Additional Director of Income Tax, which revealed that unaccounted cash loan transactions were rampant in Kolkata. These transactions were facilitated through the help of unregulated finance brokers operating in the city. Based on aforementioned information, search and survey actions at various spots of finance brokers were conducted on 30th November 2018. On perusal of certain third-party information available in the taxpayer annual summary in the profile view of the assessee that the assessee Shri Kalicharan Agarwal having PAN so and so is assessed under this jurisdiction had made. Now, my lord, just make a note of this transaction of taking, giving of cash loan from following party during the financial year 2018-19 relevant to assessment year 1920 hereunder in summarized form as per table below are as follows. And then he sets out a table. He says name Anil Kumar Kasera, PAN is so and so, financial year 18-19, information type beneficiary of cash loan taken, information value 10 crore 36 lakhs. It is seen from the above information that the assessee has entered into financial transactions in the form of taking, giving of cash loan to the tune of 10 crore 36 lakhs during the financial year 2018-19 relevant to assessment year 1920, which suggests that income chargeable to tax has escaped assessment in respect of the financial transaction made by the assessee to the tune of 10 crore 36 lakhs. Now, my lord, just stopping here, the assessing officer is probably not cognizant that there are separate income tax implications for taking of loan and giving of loan. Now, so far as giving of loan is concerned, my lord, just have section 69 and 69A.
On Income Tax Act. Can this monitor be pushed a little this side?
কিছু শোনা যাচ্ছে না।
Yes.
Section 69, my lords.
Yes, unexplained investment.
Unexplained investments, wherein the financial year immediately preceding the assessment year, the assessee had made investments which are not recorded in the books of accounts, if any, maintained by him for any source of income, and the assessee offers no explanation about the nature and source of investments, or the explanation offered by him is not in the opinion of the assessing officer satisfactory. The value of investment may be deemed to be income of the assessee of such financial year. So if there are investments out of undisclosed income not recorded in books, then to that extent that can be taxed as income under section 69. Now kindly see 69A, explain money, where in any financial year the assessee is found to be the owner of any money, bullion, jewelry or other valuable article, and such money, bullion, jewelry or valuable article is not recorded in the books of accounts, if any, maintained by him for any source of income, and the assessee offers no explanation about the nature and source of acquisition of the money, bullion, jewelry or other valuable article, or the explanation offered by him is not in the opinion of the assessing officer satisfactory. The money and the value of the bullion, jewelry or other valuable article may be deemed to be the income of the assessee for such financial year. So
Yes.
what it provides, my lord, is where the revenue finds that I am the owner of money which is not recorded in my books, then the deeming fiction says it will be taxed as the income of the year in which such discovery is made, the horse determining the year in which this income was earned. So this fiction operates once it is found as a fact that I am the owner of unexplained money. Now this will apply to a lender. My lord, the point that I am seeking to emphasize, this will apply to a lender.
Yes.
Now, so far as a borrower is concerned, my lord, the borrower has borrowed money and is under obligation to repay. It cannot become income of the borrower.
Yes.
Now, the only section under the Income Tax Act, my lord, which is relevant to a borrower who borrows cash loans is section 269 SS. If a person accepts cash loans in excess of 20,000 rupees, there is violation of section 269 SS. No person shall take or accept from any other person any loan or deposit or any specified sum otherwise than by account pay check or account pay bank draft or use of electronic clearing system through a bank account or through such other electronic mode as may be prescribed. The rest is not relevant for us. So the aggregate amount is 20,000.
Yes.
Now this can be visited, my lord, this can be visited with levy of penalty under section 271 capital D. If this is without reasonable cause.
271.
271 capital D, my lord.
Yes.
May I read, my lord? If a person takes or accepts any loan or deposit or specified sum in contravention of the provision of section 269 SS, he shall be liable to pay by way of penalty a sum equal to the amount of loan or deposit or specified sum so taken or accepted. Now, the point I'm seeking to emphasize, my lord, so far as a borrower of cash loan is concerned, there is no provision in the act to bring to tax this amount that he has borrowed as income of that person. The money belongs to the lender. The lender can be taxed under section 69A.
Yes.
So far as the borrower is concerned, the only implications are violation of section 269 SS, which can be visited with levy of penalty under 271D if the acceptance of such cash loan or deposit is without reasonable cause. Now, at this stage, my lord, at 148A stage, the assessing officer is not even sure whether I am giving loans or I am taking loans. Now, when he says at page 83, information type beneficiary of tax cash loan taken, I don't know whether I am the beneficiary or the gentleman Anil Kumar Kasera is the beneficiary. So I respond, and then kindly see page 85. This is the case related information detail. This is on the inside portal.
Yes.
The PAN number is mentioned of the assessee with the petitioner. Name is Kalicharan Agarwal. Then packet details, case packet source is search, packet source description, beneficiary of finance broker, primary source PAN is so and so, primary source name Anil Kumar Kasera. There is a search at Anil Kumar Kasera, not at the premises of the petitioner. Then it says in the information details, source PAN name, information type, cash loan given, information value 10 crore 36 lakhs, remarks beneficiary of finance broker. Then it refers to documents, specific documents analysis report, which is a letter to the AO, finance broker letter JB so and so, general document type. This is statement of Jai Bhagwan Agarwal, statement of Anil Kumar Kasera. This is the information that the assessing officer has received, on the basis of which he claims to have issued this notice under 148 AA. Now, my lord, I respond to this notice at page 88. And I deny that any such loans have been given by me. At the bottom of page 88, after setting out the notice, the last line on that page, at the outset it is submitted that no such loans were given by me as has been alleged. And then I ask for all the information that he seeks to rely upon, that needs to be confronted to me.
Yes.
And I also require him at page 89, you are required by law, the penultimate paragraph, to provide the assessee with any evidence in your possession on that basis you have alleged that the assessee had given cash loans of 10.36 crore, without which the said allegation is not sustainable, and it does not provide the assessee a fair opportunity to rebut the same. Now, thereafter, there is a notice issued under 148 AB.
Yes.
Kindly see page 91, which is the annexure.
Yes.
After setting out the table, which was from the inside portal, kindly see the paragraph. It is seen from the above information that you've entered into financial transaction of the value of 10 crore 36 lakhs during the financial year 2018-19, relevant to assessment year 1920, but has failed to furnish 1920. I thought this is factually incorrect. In fact, in my writ petition that I filed before the learned single judge at page 49, this fact is coming out that I have filed a return of income. So this information to begin with is not borne out from record, is factually incorrect. My lord will see page 49, para 5 on that page. Return was filed disclosing income of 28.97 lakhs on 6 July 2019. Page 49, para 5. That was part of the writ petition, my lord.
Yes.
The writ petition starts at page 38. Now, coming back to page 91. So he asked me to furnish my own submission, explaining the matter along with certain clarification information, provide a brief note about various sources of your income, nature of activities, copy of income tax return, computation of income, copy of financial statement, please furnish marked copy of a bank statement, clarity how above transactions have been reflected, kindly provide justification along with supporting documentary evidence. Now, this is the
Now the
information. Sorry,
seven information which is called for
right.
is almost identical to the information called clarification sought in the 148A notice.
That's right, my lord. Now, kindly see, again, he gives at page 94 the case related information. At page 96, this is the letter that he referred to, analysis letter. Now, this is a cyclostyle stereotype letter issued by the Deputy Director of Income Tax Investigation to various assessing officers at page 96. And the subject is dissemination of information in the case of beneficiaries of unaccounted cash loan transactions carried out through finance brokers Savaria and Kasera. Then he explains the modus operandi and he seeks to decipher the abbreviations or the symbols used in various pages of the document that they seized from the brokers. Now kindly come to page 103, my lord.
Yes.
At 103, at the top, my lord will see relevant portion of the analysis report is furnished below. Kalicharan Agarwal, broker name is JBS, then AKK USK, name Kalicharan Agarwal, PAN so and so, related party concern, KR Infra Projects, KR Infra, grand total 7 crore 28 lakhs, 15 crore 10 lakhs, and 32 lakhs. Group name Kalicharan Agarwal, KR Infra, potential lender or borrower status, lender. Lenders annexure reference
Connection got disrupted. There is also echo.
Yes, my lord. Today it's internet related issues, my lord.
It is the echoes at the other end.
At the end,
You send a message to
my
them.
lord.
Now, what happened to the writ petition?
Writ petition, my lord, got dismissed with the
Dismissed.
facts, got dismissed.
Sent to ED.
But you have not supplied those documents.
No, my lord, what happened? My lord, I shall, my lord,
See, 148A, what is the scope? 148 small a, capital A within bracket small a.
my lord.
There should be an inquiry. No?
It starts from my lord, page 82 of my lord, the stay petition, wherein my lord, we had been very categorical on the score, my lord, on the base on which my lord we propose to my lord reassess. And I shall my lord apprise your lordship with regard to the my lord materials, my lord. In fact, this is a case wherein my lord started from 148AA, all the steps has been followed.
My lord, can my lords hear me?
Wherein my lord, there
Am I
were
audible, my lord?
where the materials were supplied under 148AB. In fact, the assessee my lord to reply on the materials that has revealed during the course of the investigations. My lord, there is an investigation, the detail of which my lord has been provided categorically disclosing all the statements, materials, and documents, my lord, on the basis of which my lord, the authority proposed to reassess the assessment, my lord, has been supplied to the assessee. Conclusive, my lord, opportunities has been.
Oh, no. But once you have resorted to 148A procedure, then you have to follow whatever
Yes.
is stipulated under clause B, clause C, clause D.
My lord.
But what has he done here?
I would be beseeching your lordship
Straight
that.
away he issued a 148AB notice.
No, my lord, prior to that,
No, my lord.
148A.
My lord, can I come in, my lord? If my lords give me that indulgence, let me complete.
Yes, sir.
My lord, so the point that I'm making, and I'll make good the proposition, my learned friend said they have followed the procedure. I will show it's a comedy of errors. There is no application of mine. I was just building up my case. So
Yes.
here, he is not even sure. He says potential cash lent, possible financial transaction, potential lender or borrower. Right, my lord? At page 103.
Yes.
Now, my lord will see first party says potential cash lent is 7.13 crores. Second part at under para 21, he says potential cash lent 15.10 crores. My lords have this?
Yes,
And he gives various names of different entities. And then he comes to page 106. He refers to section 69A. That 69A applies to case of lenders.
lenders.
Right, my lord?
Yes,
Now, along with this, he gives me a statement of Anil Kumar Kasera at page 108.
yes,
My lord, it is extremely surprising that there is not one question raised to Anil Kumar Kasera about the cash loan he has given from me or received from me. There is not even one question in this entire statement. And this is an ex parte statement recorded during the course of search at his premises. This would have been first-hand information.
yes,
So this is the statement of Anil Kumar Kasera that they have given to me, which continues up to page number 127, 26, 127, my lords can see. Then at page 128, there is another statement of Jai Bhagwan Agarwal. Again, no question raised.
yes.
Now, my response to the 148 AB is at page 136.
That is in volume 2, is it?
That is at 151 is volume 2, I think, sir. Volume 2 is starting from page 151, stay petition volume 2. It being the first volume, I guess, my lord.
That's one.
This is
136.
136. It is shown as P4.
Yes.
My lords have it.
Yeah, we have got it.
Now, this is my response. Kindly see at 138. At the top, on a perusal of the above, it is noted that the alleged primary source of information is Shri Anil Kumar Kasera. His statement has also been enclosed with the present notice. On a perusal of the said statement, it is noted that there is no reference to the assessee's name anywhere in the said statement. Even on perusal of the statement of Jai Bhagwan Agarwal, it is noted that there is no reference to the assessee's name anywhere in the said statement. As such, it is not understood as to how it has been inferred by you on the basis of the said statements that the assessee has given cash loans when the assessee has not even been mentioned once in the entire statement. Further, on perusal of the letter dated 10/12/2021 issued by the investigation wing, which I showed to my lord, it is seen that the name of the assessee has been mentioned. The relevant extract is reproduced. This is the extract that is reproduced. Potential cash lent 7.13 crores. Potential cash lent 15.10 crores. Here, please note that the statement of USK was not enclosed with the present notice. Further, in the said letter, there is reference to some Excel sheet wherein the name of the assessee has supposedly been mentioned. However, a copy of the said Excel sheet was not enclosed with the present notice issued under 148 AA. Therefore, it is evident that again, entire related documents have not been supplied to the assessee. Further, please note that in the said letter, it is mentioned potential cash lent to various borrowers of 7.13 crores and potential cash lent to various borrowers of 15.1 crore. The word potential clearly suggests that the department does not have any definite information, and the case of the assessee has been proposed to be reopened for the sake of making roving and fishing inquiries, more so when the statements of Jai Bhagwan Agarwal and Anil Kumar Kasera do not anywhere mention the name of the assessee. The information shared itself is not definite and appears to be a matter of guesswork without being based on any material on record. Further, in the case related information detail, the information value is reported at 10.36 crores, and in the letter dated 10/12, the same is reported at 7.13 crores and 15 crores. Thus, it is clear that your good self does not have even any definite information with respect to the amount of cash loans allegedly involved during the relevant year. The entire proceeding appears to be a matter of guesswork with an intent to simply make roving and fishing inquiries to somehow determine if the assessee actually had any income which had escaped assessment. Here, please note that your good soul is required by law to provide the assessee with any evidence in your possession on the basis of which you have alleged that the assessee had made cash loan transaction of 10.36 crores or 7.13 crores or 15.10 crore, without which the said allegation is not sustainable and provide fair opportunity. Now, thereafter, another notice under 148 AB is issued, where the annexure at 141
Yes.
provides some documents, my lord.
Yes,
At 143, there is name of Kalicharan Agarwal, Amar Securities. Different kind of names are there. So these are Excel sheets that are supplied to me.
yes.
And then,
170.
yes, my lord. Then I file a response. Kindly see my response at 170. I mentioned to him that I did a Google search and found out how many people use the name KC Agarwal, Kalicharan Agarwal. And I said, this is a very common name. And the Google search shows that there are many people by this name. So there is nothing to impute these transactions, these alleged transactions to me. And especially when there is nothing in the statements that this belongs to me. Then I have also said you are not even sure of the quantum on the basis of which you allege 10 crores, 7 crores, 15 crores, which is at page 171 in this paragraph.
Yes,
Now, my lord, then kindly see, I refer to my lord judgment in Girdhar Gopal Dalmia at page 172.
yes,
And I also point out that there is no basis that you have suggested. Now, my lord, at 177 is the order impugned under section 148 AD.
80.
Yes. In this order, he sets out what he assumes to be the modus operandi. At 180, he refers to various statements recorded that the brokers explain the modus operandi.
Yes,
At 181, again, he refers to the table of 10 crore 36 lakhs. He refers to section 69A. He refers to 69A read with 115 BBE. Then he says the name para 11, name of the assessee Kalicharan Agarwal has been identified as a beneficiary of unaccounted cash loan transaction to the tune of 10 crores. Then at page 183, my lords, he records para 16. From a perusal of the above submission, it is clear that the assessee had transaction with broker Anil Kumar Kasera. All documents received from investigation wing in respect of the assessee were forwarded to the assessee. The assessee has not commented on such documents it is forwarded. I can't really understand after so much objection that I have raised. But then kindly see the next paragraph, the third paragraph. What is his conclusion? The last line I am reading, my lord, this is the operative part of the order. All these assessee related data leave no ground of doubt that the assessee was involved in taking of cash loan as stated above. So according to him, I am a borrower of cash loan of 10.36 crores. And I ask myself the question, as a borrower, can I be assessed on this amount of 10.36 crores? If according to you, without anything more, take this to be correct for the time being. If I have taken a cash loan, there is no way you can assess it as my income. There is no provision in the act on which this can be alleged that this is income escaping assessment. So the very jurisdictional condition, kindly see, is dropped that 7 crores, he dropped the 15 crores and rightly so, which he said was potential cash.
he has restricted it only to this
10 crores,
that
10
is
and cash loan taken.
cash loan taken. And what happened to your writ petition?
No, the writ petition, the learned single judge said that there is no jurisdictional condition made out with respect to the challenge to the initiation of proceedings. There is no violation of principles of natural justice. If my lord will just see page number 3. Considering the facts and circumstances just after the quotation, my lord. and the submission of the parties and the aforesaid impugned order, I find this is not a case which falls in those category of cases where the impugned proceeding initiated is without jurisdiction, or the authority who was initiated the impugned proceeding is having inherent lack of jurisdiction, or that any procedural irregularity has been committed while passing the impugned order, or there is any violation of principles of natural justice, or the impugned proceeding is patently contrary to any provisions of law. My lord, just stopping here, the jurisdictional condition, and that has been laid down since time immemorial, for assuming jurisdiction is there must be live link between the information received and the belief formed that income liable to tax has escaped assessment. My respectful submission is, without anything more, going by the satisfaction reached by the AO that this is a cash loan taken, my respectful submission is, how does it lead to assumption of jurisdiction under section 148 when there is no provision in the statute to bring the cash loan taken as income liable to tax in the hands of the borrower? Without that apart, that I am otherwise denying any such transaction, and you have no evidence to connect such transaction to the assessee. When I raised the objection and I pointed out the Google search, you dropped the issue or the allegation with respect to two amounts that Kali Charan could refer to anybody. You have recorded the statement of Anil Kumar Kasera. There is no question, curiously no question raised to him about the cash loan taken by the petitioner before my lords. So what is the evidence with the department to connect the assessee to these material that they claim to have found at the search in the search at the premises of Anil Kumar Kasera? So clearly the jurisdictional condition for assumption under section 148 has clearly not been made out, and the learned single judge, in my respectful submission, erred in upholding the initiation of proceeding. And not that, my lord, he further referred the matter, directed the principal commissioner, chief commissioner of income tax to refer the matter to ED, saying this is a financial scam. Kindly see page 5. This court, in the facts and circumstances of the case and considering the nature of huge financial scam, is not inclined to entertain this writ petition by exercising its constitutional writ jurisdiction under Article 226 of the Constitution of India. The Principal Chief Commissioner of Income Tax, West Bengal and Sikkim, is directed to refer this case along with all other cases involving Anil Kasera, where similar modus operandi has been adopted relating to unaccounted cash loan, to the Enforcement Directorate, and file compliance report before this court on 30th June 2023. I have placed by way of a supplementary evidence, a supplementary affidavit, the compliance report that they filed before the learned single judge.
May I file this supplementary?
But in the grounds raised in the writ petition,
Yes, my lord.
specific ground raised that the alleged borrower cannot be brought to tax in the hands of the assessee.
No, I have denied the transaction altogether, my lord.
That has been at the
Right.
first instance.
Right.
You have said that you have neither received loans nor
Right.
given.
Right,
That-
right.
But in the grounds, this question of law which you have now raised,
Right, my lord.
referring to 269 SS, 271
Right, my
capital.
lord.
So I think that specific ground was not raised in the writ
It was not
petition.
raised, my lord, for the reason that according to the revenue, they have themselves referred to section 69A and 115 BBE as applicable in the case of lenders. Now, when you ultimately reach a finding that the income alleged to have escaped assessment is the cash loan taken, it is clearly contrary to the provisions of law.
In this appeal, that ground has been raised.
My lord, I have said, not specifically, my lord. We have basically said there is no escapement of income.
This is possibly, my lord, first time this ground is taken before your lordship. In the memo of appeal, my lord, that ground is not containing, my lord.
It's a question of law.
My lord, I shall have also try to address this.
No, affidavits were not called for.
No, affidavits are not called for.
And my lord, I was told, I am acting on instructions, that this reference to the ED was made after the matter had already been heard and hearing concluded. And then it was shown in a separate list to be mentioned matters.
No, my lord, if I could, my lord, only indicate to your lordship.
No, you file your affidavit. We'll decide this issue.
My lord.
My lord.
We have heard Mr. Ajay Oral and please take senior advocate appearing for the appellant, assisted by Mr. Saurabh Bagarial and an advocate for the appellant, and Mr. Tilak Mitro and Mr. Prithu Doria, and senior standing counsel for. In this appeal, one of the questions of law which has to be considered is whether the alleged borrower by the assessee can be brought to tax in the hands of the assessee. The learned senior advocate has referred to the various provisions of the Income Tax Act 1961, more particularly section 69, 69A, section 269 capital S, and section 271 capital B, to point out that there is no provision to bring the alleged borrower as income in the hands of the assessee. Further, the other grounds touching upon the jurisdiction of the officer and the procedural impropriety have also been questioned. The substantial challenge to the reopening proceedings is on the basis that the department did not have definite information with regard to definite information for recording satisfaction that the assessment has to be reopened. We find that the writ petition was dismissed at the admission stage, and there has also been a direction by the learned single bench to the Principal Chief Commissioner of Income Tax, West Bengal and Sikkim, to refer the matter to the Enforcement Directorate. The correctness of this direction is also to be considered in this appeal. Thus, we find that the appellant has made out a prima facie case for entertaining this appeal. Accordingly, the appeal is admitted. The order impugned shall remain stay till the disposal of the appeal. The respondents are directed to file their affidavit in opposition within 3 weeks from date. Reply, if any, within 2 weeks thereafter. Let the matter appear on so and so date.
I shall indicate to your lordship, my lord, in persons to your lordship, my lord, the learned single judge's order, my lord, the matter has already been referred to ED.
You communicate the stay order. The Principal Chief Commissioner of Income Tax, West Bengal and Sikkim, is directed to communicate this order to the Enforcement Directorate, since it is submitted by the learned senior standing counsel that already the matter has been referred to the Enforcement Directorate. In the light of the order of stay granted by this court, the Enforcement Directorate shall not proceed further until further orders in this appeal.
Extremely grateful, my lord. Much obliged.
Yes.
Item number 2.
I'm grateful, my lord.
May I please the lordship's my lord?
Yes, sir.
The two is applying for the appellant, my lord. And the senior counsel is applying online on Delhi.
My lord, I'm appearing on behalf of the Board of Waqf.
Yes.
My lord, very briefly, my lord, to indicate the factual background. There is an appeal from the.
My lords, I'm sorry to intervene, my lords. I'm so sorry to intervene, my lords. Mr. Joy Saha, senior advocate, my lords, he's on his legs, my lord. I'm requesting for a pass over, my lords. If it's possible, my lords. He's appearing for the respondent number 5, Mutawalli, my lords.
But the board is appearing here as the respondent 1.
And who's the
contestant?
Who's the
board? Is the board?
We also the contesting. We are also the contesting respondents.
Appearing on behalf of the Board of Waqf.
Yeah, that's right.
The Waqf board.
They are
the one who issued the notice.
We are the Mutawallis, my lords. We are also affected.
Kindly go through the order first.
But Passover may be difficult today.
Then, my lords, if Friday, my lords, could be possible, my lords. I'll be really grateful, my lords.
I'm sorry, my lord, I had I missed.
My lords, the board shall not proceed under 54, my lords, till for 2 days, my lords. If it pleases, my lords.
Lordship, if it can be on Friday, if possible.
Yes, my lords.
Lord, I would have some difficulties.
So what was the impugned communication, sir? Notice under 54.
Yeah, that's right. My lord, may I just very briefly indicate to your lordships, my
When
lord?
you don't proceed to the notice, we'll have a
No, my lord, I am opposing the prayer of the appellant lordship.
appellant is not asking for passover. Your contesting
Muthuwali.
respondent is
Muthuwali is
along with
asking.
you. The fifth respondent is asking for a passover.
My lord, I am not, lordship, I am the board of Waqf. Lordship, under the statute, I have the right to issue notice.
That is correct. We will consider the appeal subject to convenience of all the advocates. He says
I'm
senior.
grateful.
If your lordship only take up this matter on Friday, we will not proceed any formal order is required. I will not proceed. I will
Instead of this Friday, next Wednesday.
next.
Wednesday.
My lord, that is
Grateful.
some difficulty, my lord, due to my lord Idul Fitr. I have to go my native on
Then my lord, we'll have it on Monday, my lord.
Thursday is my lord, the festival. Then next
Anju,
or Monday.
Monday,
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 I have
my
no
lord. Monday, my lord.
Monday.
My lord, if your lordship I would request your lordship to kindly take it up Friday week. That is not this Friday, the coming Friday.
Friday week, I have no, my lord, I have.
Then don't ask for a Passover.
need
You
it
can't have
delayed.
it both ways.
After I will return back on Sunday, lordship.
Friday week.
Friday week মানে কি?
Friday week.
Friday পরের Friday.
Friday থাকছি না আমি।
এই Friday নয়, তার পরের Friday।
পরের Friday থাকছি
থাকছেন
না।
না। সেটা গাঙ্গুলি সাহেব একটু
So then we can have it on 3rd July.
Lordship.
Lordship, Mr. Shaha is not in Calcutta on 3rd July, 3rd and 4th.
He's not answering this phone yet.
Then 5th July.
5th July.
Next
If
week,
lordship,
this Friday,
take up this matter, my lord, coming Friday, I have no objection.
Friday, some difficult.
Lords.
5th July, my lord.
5th July.
Convenient.
It's for the parties. The learned advocate appearing for the private respondent seeks for a passover on account of the business of this court. It is not the request for passover is not being able to be considered. And as agreed to by the learned advocates for the parties, let the matter appear in the same position on 5th July. In the meantime,
So grateful.
respondent board shall not proceed further in pursuance to the notices which were impugned in the writ petition.
Lordship, please.
That has been undertaken by the learned standing council for the Waqf board. Released on 5th July.
Lordship,
So
please.
grateful.
Next,
So great.
Matter to appear on 20.
Item number 3, public interest litigation.
yes.
This is my application. My lord, this public interest litigation, my lord, is directed at, my lord, preserving and protecting the tramways of Calcutta from being gradually phased out because of, my lord, official apathy and mismanagement. Now, my lord, as your lordship knows, my lord, the historical association of the Calcutta tramways, my lord, it began way back in 1873 as a means of horse-drawn carriage in 1873. Then, my lord, by 1905, my lord, the entire routes were electrified. The process of electrification came to an end. And then, my lord, in due course, my lord, the tramways, my lord, spread its network from the northern extremity of Calcutta, my lord, then, my lord, Belgacha near Tala, to the southern extremity of Calcutta, my lord, Taliganj, my lord. Just from Tala to Taliganj, my lord, it spread its network. And my lord, is running, my lord, as a mode of India's first public transport, if I may put it that way. Well, due course, my lord, as your lordship knows, my lord, the Calcutta tramways have become an inseparable part of Calcutta. In a way, my lord, it became a symbol of Calcutta. It entered the local literature. Your lordship will be interested to know that, my lord, even Tagore, my lord, has depicted Calcutta tramways as a, my lord, mode of transport where, my lord, there is a budding romance between two young passengers of the day. And, my lord, your lordship, my lord, how the Calcutta tramways is celebrated Lordship will be pleased to look at a picture in 1947 Independence Day, which was published, my lord. My lord, may I show you Lordship, Bengali magazine, how the people are celebrating, my lord, by riding on each and every compartment, nook and corner of 2 tramway compartments. And my lord, Lordship can be pleased to look at this, my lord, picture. It speaks for itself. My lord, the date is 15th August 1947. It's Bengali magazine Desh.
But in another petition, you have granted an injunction
Yes.
not to remove the tracks.
Not to remove the tracks and not to fill it up with bitumen. That is so many.
That is in this writ petition or?
No, separately. That's pending.
United for better living in that.
Oh.
That is pending.
And now what is the report which is directed to be?
Well, the report is there, my lord. I shall draw your lordship's attention to the report, my lord. My lord, before that, I mean, tell your lordship, my lord, these.
And it before your lordships, my lord. My lord, I had requested, my lord, the state, my lord, to come out, my lord, with a policy on this. Not, my lord, because, my lord, tramways is necessarily the most ecologically best way to travel. Lord, I think, my lord, more importantly, there is a issue of heritage and legacy.
Exactly.
So I wanted, my lord, a policy in this regard. And in fact, my lord, to use the language of the Supreme Court, my lord, I'm willing to have a conversation with your lordships on this. Because, my lord, it is something, my lord, at least even in my college days, my lord, part of the journey was on a tram. Now, there is one view today which says that the need for today is a faster mode of transport which will carry more people. Now, that might be an economic aspect that might be very important for policy making. But, my lord, as far as, my lord, heritage is concerned, my lord, that's where I think, my lord, personally, my lord, that, my lord, tramways, in fact, I told my learned friend that as well on the first day that he moved. I told my learned friend, my lord.
In fact, my lord, going to gain heritage status, my lord, after continuous 150 years, they will have to apply to the UNESCO for the heritage status. 150 years is the, my lord, benchmark.
When you got the heritage status for Durga Puja, this should
My
also
lord,
have
correct.
a heritage.
My lord, that is
so.
exactly, my lord, what I
But
wanted,
if
my
they
lord,
phase
of
it out
policy.
in the meantime,
And,
then
my
no
lord,
question.
because, my lord, I cannot, and I don't think, my lord, anybody can really persuade, my lord, the state to say that all lines which were there, all tram tracks which were there, all of them have to be restored. My lord, we have to now, my lord, make, my lord, a choice. And, my lord, it's absolutely necessary, but according to me, best efforts must, my lord, must be made with regard to preservation on account of heritage. Of course, there can be modifications. I'll give you a lordship's, my lord, an issue which I was discussing, my lord, with my lord, town planners, etc. My lord, that tram runs on electricity does not mean, my lord, that it's the least polluting. The simple reason is, my lord, what is being discussed with electric cars as well, there, my lord, it's disposal of the battery. And, my lord, more digital, my lord, we go, my lord, again, my lord, there is, we are not cutting wood, but there's carbon emission. So, my lord, here, my lord, to manufacture a tram, my lord, we require, my lord, iron and steel. My lord, that has, so, my lord, just to say that by itself it runs on electricity, so it's, so, my lord, we can't get into arguments here, my lord, as to who, but heritage, my lord, is where I feel, my lord, there is an absolute, my lord, clear-cut, my lord, issue.
The other issues are involved also.
No, I am not denying that other issues are involved, my lord,
But
at
the
all.
government report says that 6 rupees is the minimum tram fare. 6 rupees as in today. I shall satisfy lordship from the government's reply to my query. But I shall come to that.
The charges are something different.
Yes.
Now, has the state taken a policy decision to efface the entire tramway system?
In a way, my lord, I
So
shall,
if-
when
if
I come
that-
to
if
the
that-
report.
Wait, if that is so, whether such a policy can stand the test of reasonable
Exactly.
or can be tested. Please, sir, please. Please let your senior hear and reply. No? Art of instructing is something a fine art.
Thought that lordship will not hear.
No, I'm hearing.
No, I'll tell you, lordship, I'm a lighter vein, my lord, what, my lord, My lord, there is, my lord, Dominus Lightus here, my lord. Father, my lord, is being pulled down by the son.
No, no. So, whether the policy can be tested on the anvil of any of the settled principles.
Yes.
Constitutional laws. Secondly, whether if the policy is to be challenged, can preservation of heritage be one of the grounds on which the court can examine
Yes.
that the system should continue?
That is so. Yes.
So the people of Calcutta are very passionate about trams, and it is a iconic symbol.
Symbol of the city, yes.
Like your yellow taxis, now they are trying to phase out yellow taxis. So what has to be done as you said? Elsewhere in the world, wherever these tramways are there, they have been periodically replaced by new tram cars, which resemble the old tram cars with latest technology. So therefore, if you want to pursue, definitely the state can do it. They will say the cost of running the tram, etc. Probably if the entire stretch cannot be covered, at least major roads. In fact, when we go on the red road, if there was a tram facility, there are tracks are still there. It will be a great tourist attraction. Now all that the people have got these chariots. Now the horses are already before the court. Sick horses, etc. Horses are trying to be rehabilitated. So therefore, definitely a serious thought has to be.
No, my lord, I agree. My lord,
As far as the report is concerned,
my lord,
I shall place the report, my lord.
my lord, I'm not happy
The
with
report,
the
my lord, there is a definite intention, but I must give the due for the credit for the. There is a definite intention of running the tram in some of the routes, but there are certain deficiencies, my lord, and also contradictions in the report, my lord. I shall draw lots of attention to that. And my lord, naturally, we shall expect the state's reaction to it, whether corrective measures can be taken. But limited effort would be directed to that only. Not that, my lord, I would like to force the state to do something which it will be impossible or not economically viable for the state to do. And my lord,
No.
It is heartening for the learned advocate general to, my lord,
Suppose there is a heritage structure.
Yes.
It is under the control of the state or the center to maintain. They probably charge an entry fee of ₹2, ₹5 with camera.
It is always subsidized.
So therefore, it doesn't mean that ₹2 is going to be used to maintain that, like Victoria.
No, even I'll show to lordship the revenue aspect also.
So therefore,
so no profit, no loss basis.
Preserve heritage, it is something more.
Yes, that is so.
There cannot be a revenue barrier.
Yeah.
Suppose you want to preserve this building, definitely it's going to be very, very expensive affair. It has been neglected. All of us should admit that the building has been neglected. But to preserve it, demolition is not the solution. Preservation and renovation and restoration and upkeep is going to involve 5 times the cost of constructing a new structure.
That is
But
so.
then, for posterity, what are you leaving behind? Are you going to leave behind 30-story, 40-story buildings with steel and mortar? Or are you going to preserve these wonderful
pertinent question. Pertinent question. Very pertinent question.
That is required.
My lord, yes, my lord. So, my lord, I'll tell your lordships quite frankly. My lord, we filed a report. I'm not happy with it. I'm not happy at all, my lord, with it, because according to me, one very important central issue, my lord, has not been examined at all. That's heritage. And second thing, my lord, which has not been, my lord, dealt with at all, is, my lord, a definitive policy being spelled out. Policy is being implied. My lord, I want, my lord, an affidavit to come and say that this is our definitive.
But if that is the policy, then you should definitely have a public hearing.
Absolutely.
Definitely you will have to. When under the other laws, when you establish a big project,
Correct.
You are always
environmental clearance, my lord, there every time there is a public hearing.
The people of Calcutta need to be heard in the matter.
Correct.
They're so passionate about
Yeah.
it. And an extra mile has to be taken, or
Yes.
extra step has to be taken by the state to preserve this. Sir, dismantling effacing it entirely, it's not the solution.
And my lord, your
Milord, the old timers like us still remember, Milord, only the other day. Milord, tramways used to come near Calcutta. Milord, even the tram tracks, Milord, as the outer wall of Calcutta High Court, Milord. The plot where the sesquicentenary building now
that
stands
was a
was
tram.
previously a tram depot.
Yes, that's what I was informed about.
Trams used to
And
come.
now what they
it off.
say is, all these employees of the tramway corporation have been absorbed into the transport corporation.
Transport Corporation.
And we were doing a group 4 matter. The advocate said for the transport corporation, each bus has got 21 employees. Each state transport bus has got 21 employees because all these employees have been drafted there. Nobody is being paid salary.
And that is correct. Not
But
help,
that
my
is
lord, the
because,
transport.
Milord, they have made their tramways inoperative because of, Milord, the reason is, Milord, because the digging up of the streets by the metro railways. Now, Milord, slowly when the work is nearing completion, and that's why, Milord, the
But
report,
metro will not affect the tram.
No, no,
Because metro is going
because
under
of
No,
the
my lord,
metros, Milord, the
The
tram
old
tracks, that
construction,
the
my
tram,
lord,
Milord,
was to dig
operation had
from
to
the
be,
top rather than tunnel.
operation had to be suspended. In many of the routes, Milord, operation, Milord,
They can
still like
always
suspended.
restore it.
That took 20 years.
Milord, therefore, Milord, the report is of some, Milord, relevance.
But
As has been, Milord, I am grateful to London Advocate General, Milord. But as he is saying, Milord, there is still a scope for, Milord, the rethinking over this matter. Then, Milord, may I take this opportunity?
Committee can be formed, sir. The writ petitioner can be made a party. The other writ petitioner, suppose.
Yes, public, my lord.
Public.
My lord, I used to be part of that. Earlier. I have now left.
Therefore,
it.
I say, Milord, it's rather heartening to have him on my opposite side, Milord. I know, Milord, I was lacking sympathy for these towns. Of course, of his professional compulsions are different.
You just close your eyes and imagine you have a new tram car painted in the same color. Your suspension, your differential, everything is.
No, my lord, that's imagined. My lord, I'll tell you also one
Milord,
example. My
only
lord, I was in Greece.
Ah.
Their tram cars are there, but my lord, it's like a bus. My lord, the
Trolley bus.
a trolley bus. That's exactly how it's running.
So,
Because my lord, it's not bulky then. And my lord, the wheels, my lord, don't make that clanging noise.
pollution free. Pollution free.
Something needs to be done.
Milord, only one or two aspects.
My lord, may I
which you have done
suggest
the
one
record.
thing? May I?
Milord,
My lord,
only one or two aspects of the matter, Milord. I'm grateful, Learned Advocate General, Milord. If I may have, Milord, only, Milord, short audience, Milord. I'll draw lots of attention to what is already on record. Because they have already filed a report, Milord. And in the report, Milord, there are some rudiments of their good intentions. And, Milord, in some respect, I find the report is deficient and contradictory.
Let us
If
see.
I may draw lots of attention to that. Before that, Lordship kindly takes up my writ petition. I shall come to the report very shortly, Milord.
Yes.
Now, Milord, Lordship kindly comes to, Milord, a query, Milord, page 81 of the writ petition. Milord, that gives the picture in a nutshell, Milord, page 81 of the writ petition, the queries raised and the answers given. Milord, we have prepared a separate sheet, Milord. Milord, it states, separate sheet, Milord, it says, what is the total length of the tramway lines in the city of Calcutta? The first question asked. Milord, answer is, Milord, this is, Milord, the chart giving the questions and the answers side by side, Milord. But only, Milord, a few questions, Milord. Then, Milord, I go to the report, Milord. I will not take much of your Lordship's time. I know, Milord, the court is hard pressed for doing other medicine. What is the total length of the tramway lines in the city of Calcutta? Answer is 116.62 kilometers. That is, Milord, before the total tram tracks already laid, Milord, already laid. Then,
Yes.
number two, what is the length of the tram lines being currently used? 33.04 kilometer. Milord, 1/3 of its capacity. Then how many tram routes are currently in operation? 3. How many tram routes are not being currently operated? 20. That gives the present picture, Milord. Has any tram route been permanently closed in recent times? Traffic department did not receive official communication yet. Milord, there is a scope for rethinking. They have not yet made up their mind to close any permanent tram route, Milord. It's a silver lining in this report. Then, Milord, Lordship kindly comes to, Milord, the lower down, Milord. Milord, it states, Milord, question number 9. question number 9. The question is, how many tram depot in the city of Calcutta are owned and managed by WTC? Milord, they say there are 6 tram depots. And these 6 tram depots, Milord, also will kindly bear in mind, Milord, when they were built, land was plentiful in Calcutta. And they're all built in the prime locations of Calcutta, by the side of, Milord, the main thoroughfares, the arterial roads of Calcutta. And what is going to happen, Milord? Promoting. I'll show Lordship from the records, Milord. This has got to be prevented. Milord, next question is, Milord, number 2. How many of such tram depots are functional? 2. Out of the 6, 2, Milord, are functional. Now, what are they doing with the balance 6, Milord? The balance 4? The balance 4, Milord, we find from the reports, Milord, some of the land, parcels of land have already been given to builders for promoting, Milord. That will appear from the report. Lordship kindly comes to page 90, Milord. Page, best of all, 162. Milord, this is just the beginning of the, Milord, the activity of promoting, Milord. In 162, they say to whom they have given this land. In Taligan's tram depot, they have given an area of 240.319 kata, a big chunk of land. 240 kata means, Milord, almost 3 katas constitute nearly an acre. So big chunk of land has been given away to the promoters. His name is there, Nirvana Developing LLP. Beginning in Taliganj, and then, Milord, Lordship kindly comes to the last name in this page, Milord, where they have shown name of tram depot, Belgachia. In Belgachia, they have given 59.33 katas, Milord, to another, Milord, promoter, whose name also they have disclosed, Sachi Developers. These are very well-known promoters in Calcutta. And, Milord, my instructions are, Milord, that promoting has already begun right earnest in these 2 trams.
And they are all private promoters.
Private promoters.
So
Both of them are private.
The government has sold the land.
Yes. Yes.
Page 90.
Page 92.
Page 90.
Page 92 is there. And, Milord, they have said so. In the reply, they have disclosed the name, Milord. I shall. In page 92, the names are there. Lordship looks at page 92. The government has disclosed the names. Yes. Government have disclosed the names. Milord, Lordship sees it.
No,
Now,
nobody opposed to the sale, is it? This is government land.
It's a tramways land.
Pardon?
Tramways land.
Tramways.
Government land.
Yes. It's a government-owned corporation or an organization. And it can't be treated as a disinvestment. It's property.
Tenders were floated, Milord. Tenders were floated, and then.
But nobody opposed the tender.
Milord, at that time, Milord, I'm afraid, Milord, that is not done. I'm afraid that is not done. But still, then substantial other land is still left.
That is right. But
even
then
after,
if it has not been challenged at the appropriate time, that process is irreversible. So whatever is left needs to be preserved.
Should be preserved. And therefore, Milord, this scope up in some sort of, Milord, prohibitive order.
See, it's what is it? Purely, we can't have a judicial remedy in this. There should be a political will.
Exactly.
There should be a political
goodwill.
The political will should be there to preserve this heritage status. And if that is so, how best it can be restored? If not, the answer, in fact, the total length was 116.62 kilometers.
Yes.
Currently, what is being used is 33.04 kilometers.
Truncated.
So at least this 33.04 kilometers should be put into operation at the first phase. And it will be a major tourist attraction, sir. It will be a major tourist attraction.
Exactly.
And certain routes, you can have premium tickets also. Because they say there are totally 8 air-conditioned
tram cars.
So if suppose they improve the infrastructure, this 8 can become 20 or 25. There will be a lot of footfall.
Tourists
who avail And there can be premium charges which they will be willing to pay.
That
Like,
is so.
see, these toy trains are operated Darjeeling. In fact, this 1852, what is that? The steam engine loco. It's still being.
Yes, my lord, the
It is-
the
what
toy
is it
train to
called?
Darjeeling, my lord,
Darjeeling Himalayan Railways, my lord. It's still there, it's being preserved.
I've got
The
a
railway
small,
museum.
I've got a small table model in my chambers.
my lord, at Ghum.
Huh?
At Ghum, my lord.
Whom is the
Yes,
workshop,
yes.
and that loco is called. I'll tell you, it's there in the chamber. So it's still it is running, still it is functional.
Yes,
There is a
It
That's-
was sometime built in.
it has attained heritage status, my lord. Under UNESCO.
I have been to that Doom workshop. Still, they are doing a lot of things, and they are supplying certain material, including the sleepers, etc., for the entire northeastern and eastern railway. Fully functional workshop.
Oh, that it is, my lord. I'm aware of that, my lord, because till
So, if there is a will with the railways, why not a will with the state government? Why can't the state government?
No, correct, my lord. I'm not saying, my lord, that one shouldn't have that will. My lord, I'm entirely, my lord, with.
So, what we can do is, sir, our suggestion would be to form a committee. The committee should have governmental representatives and public spirited people like the red petitioners, some NGOs, etc., which will, and the conservationists, heritage experts, 10, 12 member, which will examine the policy. Because as of now, from what submission of a learned advocate general, there appears to be no definite policy taken by the government saying that this cannot be done for X, Y, Z reasons. If that policy is taken, we can test it. If there is something vague, saying that it is not feasible, employees can't be paid salary, this metro is running, traffic is increased, that's no answer at all. That's no answer.
That is so.
And we can direct the state to suggest the committee, and we will also suggest that public spirited persons like the red petitioner be made part of the committee, like a 10-member committee. They can examine the feasibility and they can give a report. Based on the report, we monitor the matter.
And in the meantime, there's some status quo in respect
Yes.
further sale of the assets and the
No problem. My lord, kindly have a.
capital assets and
Public, where your lordships, my lord, have already passed an interim order. My lord, the prayer there was, my lord, to constitute a committee of experts. There is specifically, my lord, a prayer there. In fact, both matters can be tagged on. And my lord, this, my lord.
But in the meantime, don't sell the lands.
Your lordship provides for it, my lord. I am, my lord, I won't.
But it's very shocking that
No, my lord, all these projects, something has come up, my lord, and my lord, well publicized projects. My lord, now, my lord, where your lordships would have shifted, my lord, Quest Mall, my lord, was CSC property. My lord, the tramways, my lord, were next to it, my lord. That, my lord, acquisition and my lord, development, my lord, happened then, long ago. No one questioned it, my lord. There was a tender process, my lord, fair price, etc., my lord, whatever, my lord, happened.
But normally you dispose of these government largesse or land unless and until you don't require it for any public purpose. See, now there is severe dearth of space for government offices,
Correct.
etc. Government housing projects.
My lord, that might have happened.
and without it necessarily involves felling of trees, without destruction of the ecological balance, all these building projects. But another material thing, at page 162, the money that they have recovered, your lordship will see 229 crore money they have recovered by sale of this.
Nothing, sir. It's pittance.
It's nothing, but how they have spent it,
2,000 crores now.
this is by sale of capital assets as well. Money is coming, but how they are spending? But I believe this is revenue expenditure. They say the money recovered from sale of land was utilized for the implementation of VRS and repayment of loan payable to government of West Bengal. Well, not for acquiring another capital asset. And moreover, at page 140, I have given pictures where the trump cards are being sold as junk in various depots. The auction will say
That's because corrosion. What else to do?
Because of corrosion and the long unused
So they have to build new cars with modern technology, with more effective braking system, that can be easily done. We have got this new trains, ICF coaches are there. They are,
Well, some of the tram cars, they are already in their disposal, my lord, let them run those
that
tram.
can be restored,
That can be
but they are
restored
in bad shape, sir. I have seen a couple of tram cars. Bad shape.
because of continued neglect.
Nobody buys tickets. That's the problem. The public needs to be sensitized.
My lord,
They
that
hop
is-
in, hop out.
my lord, what-
Because it goes in a speed that anybody can get into a running.
My lord, it's faster than the hill train, my lord. I can tell you.
Fallen from your lordship, my lord, cannot be, my lord, unexceptional. But the question is, my lord, at the same time, what is the effort visible to improve its function? On the other hand, my lord, lordship can see
Alright,
the
we'll-
inherent contradiction between the stand taken by the authorities,
By this public interest litigation,
my lord, with regard to, my lord, meant with
we
regard
will
to
issue interim direction. We'll keep the matter.
and
pending.
preservation of the present
Yes,
assets.
yes. By way of this public interest litigation. Filed by a practicing advocate of this court.
They gave this.
Who also happens to be a tram enthusiast. The direction has been sought for upon the respondents to disclose the policy decisions and cabinet decisions regarding plying of trams in the city of Kolkata and to operate tram service in the existing route and resume services of the suspended routes. The petitioner also seeks for issuance of a writ of mandamus to file a report by a third party independent agency regarding the independent investigating agency regarding the dealing with the land properties of CTC and the amount rolled out through promoters / developers for the development over the land of CTC, as also on the purchase of trolley buses and electric buses and the scheme framed for the same for the period from 2080 onwards. The petitioner also seeks for a direction, for a specific direction to take all steps for restoration of tram service and also for a direction upon the respondent authorities to disclose the sale proceeds from the auction sale of tram cars for the period 2018 onwards. The matter, the writ petition has been pending for nearly a year, and in terms of the directions issued. On 23rd September 2022, a report was required to be filed by the respondents. The matter subsequently was heard on 23rd December 2022 and 3rd February 2022, on which dates the matter was adjourned for filing the report. On 3rd February 2022, sorry. Thereafter, a report had been filed, and by order dated 17th March 2023, time for granted to file exception to the report. Thereafter, the matter has been listed today.
Exception.
This court.
Exception.
In terms of the directions issued, the petitioner has filed the exceptions to the report. After we have heard the learned senior advocate appearing for the appellant of a petitioner and the learned advocate general appearing for the respondent state, we find that the authorities who have taken a decision to suspend the tram services or to restrict its operations have not had a broader vision of the whole concept of operating tram services in Kolkata. It is an undisputed fact that trams in Kolkata are part of its heritage. The respondents, being a welfare state, are also to preserve heritage for the purpose of not only enjoying the same for the present, but also to preserve the same for posterity. When the public of Calcutta are very proud that the Durga Puja festival has been given a heritage tag by the UNESCO, equally they should be proud to have the tram services restored, maintained, and operated efficiently in the city of Kolkata. Undoubtedly, expenses are required to be incurred for preserving such heritage status, and at times the expenses will definitely be more than the expenses which is normally required to be spent for new projects. Nevertheless, the respondent state has to take a proactive step in this regard to rethink on the decision taken by them. On perusal of the report filed by the respondents, we find that there is no definite policy decision taken by the government to scrap the entire tramways in the city of Kolkata. In another petition, which was filed as a public interest litigation, an interim order has been granted restraining the respondents from dismantling the tramway lines which are presently in existence, though the court was informed that certain lines have already been uprooted and filled up and roads have been laid. The petitioner had filed an application under the provisions of the Right to Information Act, within bracket RTI Act, seeking for various details. And from the details we find, from the reply given by the public information officer, it is seen that the total length of the tramway lines in the city of Kolkata was 116.62 kilometers. And the tramway lines currently used by WBTC is only 33.04 kilometers. And trams are operated only in 3 routes. And in 20 routes, it has not been operated. This court was surprised to know that substantial assets of CTC, which were used either as tram sheds or depots, have been sold by way of public auction, and private parties have purchased the said properties. Projects have come up on those properties. It is not very clear as to what happened to those funds realized. As could be gathered from the information furnished, it has been utilized to repay the loans, etc. Admittedly, the properties of CTC, which were used as depots or workshops or tram sheds, are properties of the government. And
The government, the properties of the tramway company.
Of the tramway company, which is a wholly owned government organization. Therefore, if such assets are to be disposed of, which have a public character, a serious thought process is required, since several governmental projects may require land, and unless and until the governmental projects, unless and until there is a clear stand that such land owned by a public sector is not required for any public purpose or for governmental purposes, then and then only the said properties are put up for auction. Be that as it may, we are required to consider as to what has to be done in the present circumstances. As pointed out earlier, the report submitted by the respondents does not address the issue from preservation of the heritage. This is the most important aspect which has to be examined, which has lost the attention of the respondents. Therefore, we are of the view that the appropriate authority of the respondent, namely the first respondent, should immediately form a committee consisting of the relevant government representatives along with the public who are tram enthusiasts, and we recommend that that this writ petitioner be also included in the committee, apart from the representatives of the NGO which had filed WPA number.
Hello, that's WPAP number 214 of 2023.
214 of 2020.
And my lord, the name is People United for Better Living in Calcutta, in bracket public.
And such other organizations which would be interested in preserving the heritage and culture. The committee should also consist of experts in the field of preservation of heritage and culture, drawn from different sources. And it should be a broad-based committee with independent minds, so that the committee can examine and submit a report to this court as to how the tram services can be restored, maintained and preserved in the city of Kolkata. The respondent state should not treat this writ petition as an adversarial writ petition, but should appreciate the cause which has been flagged by the petitioner. It is the duty of the state to preserve the heritage. Full stop. This court can take judicial notice of the fact that several heritage structures in the state are being preserved by the state, either fully funded by the state or partly funded by the center. Therefore, we are of the clear view that the tram services should not be totally effaced or disbanded in the city of Kolkata. Furthermore, if the tram services are to commence operations, the tram sheds and depots are required for its efficient and effective operation. Therefore, the respondents are restrained from selling or putting up for sale by way of public auction any of the properties of the West Bengal Transport Corporation or the city Calcutta Tramways Corporation without until further orders in this writ petition. The first respondent is directed to suggest the names of the committee directed to be formed by filing a report before this court on the next hearing, and the court will finalize as to the constitution of such committee and also frame the terms of reference to the committee for them to deliberate and to submit a report. The first respondent is directed to suggest the names of the committee members within a period of 3 weeks from date, and let this writ petition appear on so and so date along with WPO, WPA, what that number we said?
214. 214 of 2020.
Yes.
We have only one thing, Milord. My learned friend, Milord, the petitioner is willing to serve in the committee.
Pardon?
She is willing to serve in the committee.
Very nice. We'll have AG also in the committee.
No.
Yeah. Very much welcome.
He'll be in dual capacity.
The dual capacity, and that will give an added dimension and advantage to the committee. If it comments
You
to
also take down some names of people who got this flair for heritage. But I am told there is some litigation where an order was passed that this building is not a heritage structure. Is it right? That litigation was when there is a proposal to construct that one eyesore in that
Yes.
atrium, that courtyard, which has come up,
Yes,
and there was some challenge. to
yes,
it.
my lord, the
That is
challenge
the
was, my
division
lord.
bench judgment, my lord. I've seen the
Yes,
judge.
my lord,
I've seen the
my
judge.
lord, I had, my lord, used that judgment, your lordships would recall. My lord, when, my lord, the English Bazaar, my lord,
Yes, yes.
so there was a judgment, it was argued there that there is no valid heritage committee, therefore there is no valid declaration of.
But
heritage.
actually, state government, from what I know in my home state, the state government has constituted a committee. That committee not only going by the age. It doesn't say like merely because
No, no,
building
not
is
at all,
100
it
years
cannot
old,
be, my lord.
it won't be a heritage structure. The architecture,
Yes,
the use to which it was put to, it may be only 75 years old.
Yeah.
But what happens is even private properties are identified.
correct.
So private properties, they can't apply for demolition and reconstruction.
That is so.
It has to be only restoration. Unfortunately, those owners, they don't have the wherewithal to.
Correct, to maintain. My
Maintain.
lord, that's been an issue, my lord, your lord, like in London, Karl Marx's residence. It's a heritage
Blue
property,
plaque.
nobody
Blue
can
plaque.
touch. There's a blue plaque, it's a blue plaque property.
No plug.
So, my lord, wherever, my lord, eminent personalities have resided, like, my lord, in, my lord, Kolkata, Michael Madhusudan, that's residence. Now there's a dispute, my lord, in Kidirpur area, my lord, as to which was his residence. On that, my lord, now there's litigation. My lord, I had occasion to
Like,
appear in
there
one
is
of
a letter given by this son of Justice Sambhunath Pandit. It came to me saying that his house is in shambles, and they said, can the state do something? There are a lot of people have unauthorizedly occupied, encroachers.
My lord, in fact, in sorry, Calcutta है तो बहुत ही भारी और occupied.
Their property. Other branch of table.
There is one temple here that Karnamoy.
Yes.
And that those idol was consecrated by some, they say, a very, forget his name. And it was a huge area. And now hardly the temple precincts are, it's also got an orphanage behind it. Probably less than 1 kata. They say there is a waterway nearby. People will have bath and then come here. Huge property. I forget his name, sir. He was one of the architects of Calcutta. That is who developed for the culture, the development of Calcutta. I'll get the name. And in fact, that Pandit there said, we are not able to do anything with the encroachment. In fact, the structures on the side will resemble Dakshineshwar. That small Shiv Mandis are there. Same pattern, Karnamoy. And it is established in 1800s or 1700s.
My lord, Rani Rashmani.
Rani Rashmani was the person who constructed.
Yes.
I will tell you the name.
Find out, my lord, find out. My lord, one digression here.
Yes.
My lord, one digression here, since there is fallen from a lordship of the High Court building, my lord, there is an old book, my lord, which has, I believe, gone out of publication. My lord, written in 1909 by one Cotton, who was the barrister practicing in this court. The name of the book is Calcutta Old and New. And there, my lord, a whole chapter is devoted to Calcutta High Court, its architecture, and my lord, these pictures, my lord, which are painted by. The whole chapter is devoted, my lord, full of information regarding the Calcutta High Court. Calcutta Old and New by Cotton.
My lord, I had to appear once for my lord, the High Court, my lord, there was a public interest litigation, my lord, relating to Justice Eli MP, my lord.
Here.
Yes, my lord, of Justice Eli MP, my lord, and my lord saying, my lord, that he had been actually, he used to party every evening with Sir Warren Hastings. And in the Warren Hastings impeachment, my lord, what used to go on had been, my lord, recorded. So this should not adorn. And Justice Ruma Pal had called me and wanted me to defend it. And ultimately, because it's again heritage, my lord, we can't forget this, wipe out history.
It's
So-
painted in 1780, my lord. One of the pictures painted 1780
Because
by
we had,
Lord Jofani, a very well-known picture of the stage. Well, there's a, my lord, there is a whole list of the pictures, my lord, which are hanging all over Calcutta High Court, my lord. Names of the painters, my lord, and the background, everything is there.
my lord, in
Very-
fact,
In my parent High Court, we have got a portrait committee. I was the chairman of the portrait committee. So what we decided was for restoration,
Yes.
we had people coming in from London. We said we will not send the portrait out of the court premises.
You'll do it here in the premises itself.
You know the reason.
yes,
I-
Very difficult to distinguish the original from the fake. They are much better than the original.
Yes.
So therefore
is
we
so.
said it shine. We have got as many as more than 800 portraits. They are all these original vegetable dye colors,
Yes.
fully preserved. Only one portrait which was sent out of early Norton. What came back, they say it's not there. And it was through a governmental agency only. Because they others,
my lord, there used to be a portrait of our father of the nation, Mahatma Gandhi here, my lord. I don't know where that's gone.
anyway, sir.
And rumor had it that it was painted by Nandalal Bose.
Hmm.
And his works today are, my lord, which cannot go out of the country. Like
Where is it
Jamini.
gone? Just walked up.
My lord, your lordship should, my lord, actually check, my lord. Somebody could be lying in some go down or warehouse. I don't know, my lord. So, we're gone down with old records, but when we joined, my lord, it had a bluish background. And my lord,
Any photograph is there?
I'll try and see, my lord, if
If
there
any
is a
photograph
photograph.
is there, we will try to identify.
In fact, the other day, Justice Joymallo Bagchi and I, we were discussing that.
We'll try to do so. So you give some date.
Take it.
Much obliged.
Yes. The book you can return it to sir.
19. Amit Deshta Rekha.
Item number 4 for admission.
Identity of
করবে তো আমার তো হয়ে গেছে তুমি তো বলবে এবার
yes.
In this matter, my lord, is that customs broker matter. On the last occasion, I had given the compilation, my lord. Compilations have also been given to a learned friend, and I had already made my submissions on the first occasion. My learned friend is supposed
This composition is different.
Yes, my lord.
Then probably next week we will take it up. We'll because those third way, just Bhattacharjee. List before the Hon'ble Division Bench, which heard the matter earlier.
Item number 5.
May it please, Your Lordship. The addition has been made in this matter, my lord, on the basis of unexplained cascading under necessity. And your lordship had, my lord, had.
Where are your questions?
Yes, my lord. I'm placing.
Substantial questions of law.
My lord,
Page
the
4.
substantial question of is
Whether the
page 4. of
tribunal
the
was justified in law in not resorting to, restoring the action of the assessing officer in making addition under section 68. What did the commissioner appeals do?
My lord, tribunal had to deal with the concurrent finding of the authorities. My lord, assessment order, my lord, is appearing at page the relevant portion. I am placing page 15 of my lord this repetition, wherein my lord certain facts has been placed, and my lord, the CIT appeal in its turn, my lord, had gone to my lord elaborate those facts, and my lord had affirmed the order of the assessment officer. Now, my lord, the tribunal, while my lord dealing with this, I am placing certain my lord, the relevant facts before lordship first. The reason for which, my lord, this my lord, doubt arises is, my lord, based on certain facts which has been incorporated in page 15 of the assessment order. My lord.
So this was a 263 order.
263 exercise, my lord. Thereafter, my lord, this order has been passed.
But earlier there was a 147.
Originally 147, was then under 263 direction was made. So this order was passed, giving effect to the 263.
263, my lord. I'm placing that before lordship, my lord. Examination of the balance sheet reveals that during the year under consideration, the SSC company raised a share capital of such and such amount by issuing 4,02,750 equity share of face value of ₹10, each at a premium of ₹190, including 10,000 shares issued to the directors without premium. The SSC company was incorporated on 11th January 2008, and just within a time period of less than 3 months, had come up with the issue of share capital of more than 7 crore, that too with a premium of 19 times the face value of each shares. It is very surprising that a newly incorporated company with the promoters, having no record of any worthwhile business or reputation, has attracted subscribers to its issue of share capital with high premium. This definitely calls for investigations about the genuineness of the share capital. In other words, the substantial amount of rupees such and such credited in the books of the SSC company in the garb of the share capital, including share premium, needs investigation. It is well settled positions of law that onus of proving the credits in its books of account lies squarely on the SSC, and such proof consists of proving the identity of the subscribers or creditors, capacity of such subscribers or creditors to make such payment, and also to prove the genuineness of the transactions. Investigation was carried out by calling for informations under section 133 clause 6 of the IT Act, which specifically asks for, beside other details, the following informations: copies of trade license and subscriber of the subscriber companies, certified copy of the resolution adopted by the subscriber companies for subscribing to the share capital of the SSC company, ID proof, PAN and DIN of the directors. None of the subscriber furnishes the above details. This gives a clear indications about the background of the subscriber companies. It is also seen from the profit and loss account and balance sheet of the subscriber companies that they did not have any business activities, and their net profit were in meager few thousands of rupees only. It appears from the informations collected from the subscribers that the subscribing companies existed on papers only, with the sole purpose and activities of providing share capital to other companies like the SSC company. Further summons under section 131 of the IT Act were issued to the directors of the SSC company at the given addresses, but most of the summons were returned unserved by the India Post. However, one person, namely Sri Prakash Kumar Choube, appeared in the compliance of the summons. The statement of Sri Choube was recorded under section 131 of the IT Act on 24th of March 2014. The salient points that emerged from his statements are:
Yes.
Number one, Sri Prakash Kumar Choube has no PAN and is not assessed to income tax. Sri Choube has no idea of company, director or share capital. Sri Choube is not aware of the subscriber companies or its subscription in the share capital of the SSC's companies. During the relevant financial year, that is financial year 2007-8, Sri Choube worked as a peon in Messrs. Khaitan and Associates. Therefore, it is evident from the statement of Sri Choube that the SSC company has used the name of Sri Choube for the purpose of their directors. It is a normal practice for such paper companies to use the name of lowly paid employees like peons, drivers, etc. as directors. These relevant findings, my lord, had elaborately discussed in the order of CIT appeal, my lord, that is appearing at page 26 of my stay petition, my lord. I'm placing that before Lordship. Lordship, I've got it, page 26 of stay petition. I'm reading from my lord, paragraph number 5. I have considered the submissions of the appellant and perused the assessment order. I have also gone through the assessment record. The facts of the case have already been discussed on above. On perusal of the assessment record, it is observed that in the course of reassessment proceeding initiated by the assessment officer consequent to the order of 263 of the Act, he has issued notices under section 133(6) of the Act dated 5th March 2014, calling for various details, explanations and documents from the subscriber companies who had subscribed the share capital of the appellant company in the year under consideration. The said notices were duly served upon the respective subscriber companies, but none of the subscriber companies complied with the notices under section 133(6), and no information or documents are submitted before the AO. Further, in order to verify the genuineness of the share capital raised by the appellant company in financial year 2007-8 relevant to the assessment year 2008-9, the AO issued summon under section 113 of the Act to the erstwhile directors of the appellant company, that is Kailash Barik and Rakesh Kumar Chobe, who were the directors of the appellant company during the relevant period when the share capital was introduced by the company. The AO also issued summon to the present directors of the company, that is Krishna Mohan Pandey and Pradeep Kejriwal. However, in the case of Pradeep Kejriwal, summon was returned unserved. Kailash Barik and Krishna Mohan Pandey did not comply the summon issued by the AO. Only Rakesh Kumar Chobe, the erstwhile director, appeared before the AO. It is observed that the AO also allowed an opportunity to the appellant company to produce the directors before him, but no compliance was made by the company. The AO recorded the statement of Rakesh Kumar Chobe under section 131 of the Act on 24th March 2014. The relevant questions and answers are as under. Please identify yourself. I am Prakash Kumar Chobe, aged 32, son of Mullidhar Chobe, resident of 10 Upper such and such. Are you assessee to the income tax? No. Please state your professional occupation. I am unemployed at present. For how long you are unemployed? Since I left the job of a peon in Khaitan and Associates sometime in year 2008. Please describe the nature of activities of Mrs. Khaitan and Associates and your job profile in that. I was a peon and the job of peon involves just moving the files, delivering letters, documents, etc. Since I am not qualified enough, I could not understand the nature of activities of Mrs. Khaitan Associates. Please provide the name of key persons and address of Mrs. Khaitan Associates. Mr. Shankar Khaitan is the key person of Mrs. Khaitan Associates, and the address is 14 Prinsep Street, Kolkata. Your name appears in the record of Mrs. Astav Income Private Limited as a director. What do you know about the company? I know nothing about the company Mrs. Astav Income Private Limited. Even I do not understand the meaning of a director. The statement recorded in English was duly explained to you in Hindi. Have you understood the same clearly? Yes. So from the above statement of Prakash Kumar Chobe, who happened to be one of the directors of the appellant company during the relevant financial year, when the substantial amount of alleged share capital was claimed to be raised by issuing equity share at substantial higher rate of premium, one can easily understand the status of the appellant company and the activity in which it was involved. In the course of the appellant proceeding, it was contended by the learned heir on behalf of the appellant company that the AO did not allow the opportunity of cross-examination of Sri Rakesh Kumar Chobe. However, I fail to understand that who would have cross-examined the Sri Chobe, because he himself was the director on paper of the appellant company during the relevant period. From the statement of Sri Chobe, it is apparent that he was dummy director to the appellant company and someone else was managing the activities of the appellant company with regard to the introductions of the share capital and making investment in the shares of the other like companies. Hence, there is no substance in the submissions of the appellant company that the opportunity of cross-examination was not allowed to it. The alleged director clearly stated that he did not know anything about the company of Mrs. Astaf Income Private Limited, and even he did not know the meaning of a director. He was simply a peon in the same concern during the relevant period. Thus, the genuineness of the appellant company itself is in question. Leave aside the transaction carried on by it during the year under consideration in respect of the introductions of share capital by issuing equity shares at abnormally high rate and premium. I am of the opinion that when the appellant company itself appeared to be non-genuine, the transactions and the introductions of the share capital and share premium ought to be held as not genuine and on the facts and the circumstances of the case. So this was the relevant finding with regard to the original finding of the assessment officer, and these facts was required to be either dislodged to to ascertain a contrary view that has been taken by the assessment officer. The tribunal had gone on to exercise. If I could show the relevant portion that is happening from page 68 of the stay petition. I'm placing that before page 68, paragraph number 18. It is furnished that in the set-aside assessment proceeding, the learned assessing officer issued notices under section 131 of the Act to the present and erstwhile directors of the assessing company who did not comply with the summons, except Rakesh Kumar Chobe, whose statement was recorded. The learned assessing officer noted that Sri Rakesh Kumar Chobe is not having any PAN and not access to income tax. The learned assessing officer also noted that Sri Chobe is not having any knowledge about its either directors or share capital of the assessing company, and he was working as a PO in Messrs. Khaitan and Associates during the financial year 2007-8. And thus he came to the conclusion that Sri Rakesh Kumar Chobe was used by the assessing company just for formality's sake to comply with various statutory requirements, which is a common practice, and held that the share capital raised by the assessee is bogus, thereby adding the same to the income of the assessee under section 68 of the Act. Further, the assessee has failed to prove the identities, creditworthiness of the investors and genuineness of the transactions before the learned assessing officer. We also note from the record before us that Mr. Rakesh Kumar Chobe retracted his statement as recorded under section 131 on 26 March 2014 by affidavit which was attested on 27th March 2014 by notary public. We also note that from the evidences before us that Mr. Rakesh Kumar Chobe was holding a PAN bearing number such and such and access to tax and has regularly been filing his return of the income under the charge of I2 Ward 37/1 Kolkata. Therefore, it is clear from the above that the statements as called by the learned assessing officer under section 131 is not correct and cannot be allowed as basis for making addition. To the above extent, we note that the allegations of the assessing officer by making addition was not correct. Further, the learned assessing officer observed that the assessee company, being a newly incorporated company, has issued and raised share capital of 7 crore by issuing a shares at a premium of 19 times the face value, and also that none of the subscribers furnishes the details as requisitioned in the notices under section 136 of the Act. Besides, learned assessing officer noted that upon perusal of the profit and loss accounts, balance sheet of the share subscriber companies, it is clear that they did not have any business activities and their net worth was meager. The learned CIT appeal confirmed the order of the learned assessing officer for 3 reasons, namely its share applicants did not respond to the notices issued under section 136 of the Act, though the notices were duly served on them. Secondly, summons issued to Sri Pradip Kejriwal, present director of the company, remained unserved. And number 3, that on the basis of the statement recorded of Sri Rakesh Kumar Chobe, erstwhile director, it appears that he was a dummy director and therefore an opportunity of cross-examination could not be allowed, since Sri Rakesh Kumar Chobe himself was the director of the assessing company at the relevant point. So, my lord, I am indicating to your lordship.
Please see the direction which was issued under 263, page 13, para 19. Is set aside with the direction that he should pass the assessment order after conducting independent, detailed and complete inquiries into the subscription of share capital premium to the extent introduced in the case. AO should trace the source of share capital by inquiry into various layers through which the money has been introduced in this company as share capital. Also examine the directors subscribes the company issuing summons under 131. AO also should send etc. etc. Now you compare this with page 18. Nothing he has done. That is why the tribunal says, you come to page 69, para 19, tribunal's order. Having considered the aforesaid facts, page 69.
My lord.
Next verification done by the learned assessing officer in the proceedings under 147. That was the original assessment.
My lord.
We observed AO has carried out full investigation on share capital, share premium assessment proceedings. 147 by issuing notice of 133.6 duly supplied to the said investors. Note that successfully fully furnished all the details before the AO to prove the credit was source of money, etc. But in the set, what is that? I think some typographical mistake.
My lord, yes.
By which he means the after 263 order, but in the said assessment proceedings, there was not carried out any investigation and harped upon the fact assessee has failed to discharge its source. We note that the AO has all the records before him on the basis of which the first assessment proceedings, the assessing officer held that the investment share capital so also is genuine, whereas set aside the learner treated the same investment as bogus and non-genuine without carrying out any investigation by merely relying upon the fact summons issued 133.6 was served but not responded by the investor and also the former and present directors of the ASSI company did not comply except one Shri Rakesh Kumar Chobe. In our view, the action of the AO in making addition without complying the directions of the PCI, specifically in para 19 as reproduced, cannot be sustained. Addition has been made simply for the reason excise jurisdiction 263, setting aside the original assessment. AO's ignored facts, documents, confirmation. There is no bar in the act to issue share premium. Then they have said they have relied upon some Mumbai tribunal confirmed by Mumbai High Court, some Orissa Corporation, Delhi High Court.
Those are my lord, in the light of underscore whether my lord, this exercise was carried on by the assessment officer. Or not.
Page 72, para 22, last para. Therefore, we observe non-compliance of notice share applicants. Second ransom cannot be used to draw adverse inference against SSC as having necessary evidence also. Now, how to, we can't put this Chobe in the box here. Then page 73, para 24, fourth line from the top, we note according to the AO, he was not assessed to tax and he is not having PAN number, working as peon and so and so. We note that this observation of AO is not correct. Chobe is holding PAN, assessed to tax, filings returned, charge an ITO on the ward number, reasons before us, a statement given so and so, was retracted during the, after 2 days recording, first transaction, etc., etc. Assessing officer has not recorded any finding to show how the premium so and so unexplained. No adverse material recorded. So therefore they say the assessing officer cannot be allowed to disturb the satisfaction recorded by the first AO in the first round based upon evidence available, that too on surmises and conjecture. Because he passed an order under 263, he simply said,
no, my lord, what had happened, my lord, whether this point was, my lord, before the tribunal, my lord, when my lord, this assessment order was
they didn't question the 263 order.
My lord.
That they didn't question.
Yes.
That the tribunal has shut them out, saying that now at this juncture they cannot question. Rightly so. But what is no question?
It was more of a my lord,
This
factual.
appeal filed by the revenue under section 260 capital A of Income Tax Act 1961 within bracket the Act is directed against the order dated 26th August 2022 passed by the Income Tax Appellate Tribunal B Bench Kolkata within bracket Tribunal in ITA number 123/KOL/2015 for the assessment year 2008-9. The revenue has raised the following substantial question of law for consideration. Page number 4, only one question in para 7. We have heard Mr. Tilak Mitra, so also Mr. J.P. Ketan. The short issue which falls for consideration in this case was whether the tribunal was justified in deleting the addition made by the assessing officer under section 68 of the Act, 68 of the Act by order dated 31/3/2024, pursuant to the direction issued by the Commission of Income Tax Kolkata 1 under section 263 of the Act. After we have elaborately heard the learned advocates for the parties and carefully perused the order impugned in this appeal, we find that the tribunal has conducted a thorough factual examination as to the correctness of the order passed by the assessing officer in the second round, that is, after the direction was issued in the order passed under section 263 of the Act, dated 7/3/2013. The tribunal has noted that the first assessment which was completed was a proceedings under section 147 of the Act. And the assessing officer, in terms of the first assessing officer, in terms of explanation 3 to section 147, has called for the details of copy of bank statement, comma, details of investment, comma, details of fresh share capital, comma, details from income from other sources, comma, copy of books of accounts, and details of loans and advances. And after all those details were furnished by the assessee, the assessment was completed, holding that the assessee has fully explained the transaction and has also discharged the onus cast upon this. The Learned Tribunal, after noting as to how the first assessing officer has proceeded, considered the correctness of the assessment order dated 31/3/2014, passed pursuant to the direction issued under section 263 of the Act. The tribunal has noted that the second assessing officer failed to comply with the directions issued by the PCIT in his order dated 7/3/2013, and merely by surmises and conjectures held that that the investment in the share capital, share premium was not genuine, and that the assessee has not discharged the burden cast upon him. The tribunal has noted that the finding recorded by the first assessing officer was based on facts, and after conducting inquiry and also examining the documents which were produced. In the absence of any adverse material in the hands of the second assessing officer, the tribunal held the first assessment could not have been disturbed. Thus, considering the manner in which the tribunal has examined the issue, we find that a thorough factual examination has been done, and therefore we find that there is no question of law, much less substantial question of law, arising for consideration in this appeal. Accordingly, appeal fails, is dismissed. I'm grateful. Next.
Item number 6.
Page 5.
My lord, the short point here is, my lord,
147.
that whether GK and drive shaft has been followed in toto or not. While, because in this case, my lord, the assessment order, without giving a separate, without passing a separate order, after receiving the objections,
straight away
a composite order has been passed, my lord. My lord, the only thing I have to say, my lord, with regard to this is that when the assessment was going on, my lord, the assessee appeared several times. Before passing the composite order, the assessee did not seek any, give any objection as such, why there should be a separate order. My lord, that my lord will kindly see that portion.
But he had given his objection to the 148.
He had given his objections. Those have been dealt with in the assessment order also.
That is not sufficient.
That is not sufficient according to GK and drive shaft. But my lord, My only submission with this regard is that while the adjudication was going on, when at the time of composite hearing of the assessment, composite hearing, at that time he did not take up that objection that why didn't you pass an order, separate order. He participated in that.
He's into,
My lord.
what was the,
My lord, I will place it. I will kindly see.
but that is a mandate, no, judicial mandate to be followed consistently. Several decisions we have also held.
My lord, GK and Drive Shaft says that a separate order ought to be passed. But in this,
And the question of granting a remand also doesn't arise. Because reopening is a very, very serious business. And he had to decide it. And rightly the CITA and tribunal confirmed.
Yeah.
We leave it at this. This appeal filed by the revenue under section 260 cap play of the Income Tax Act 1960. Within bracket, the act is directed against the order dated 4th January 2023, passed with Income Tax Appellate Tribunal B Bench Kolkata within bracket tribunal in ITA number 1896/KOL/2019 for the assessment year 2014-15. The revenue has raised the following substantial questions of law for consideration. Page number 5 of the stay application. A and B. We have heard Mr. Vipul Kundalia, Mr. Prithu Doria, Mr. So and so. The short issue which falls for consideration is whether the assessing officer is mandated to pass a speaking order on the objections raised by the assessee for the reasons assigned by the assessing officer for reopening the assessment by issuing notice under section 148 of the Act. It is an admitted fact that this mandate, which has been laid down by the Hon'ble Supreme Court in the decision in GK and Drive Shafts India Limited was versus DCIT 2003-259 ITR 19 within bracket SC was not adhered to by the assessing officer. Therefore, the Commission of Income Tax Appeal 6 Kolkata within bracket CITA had rightly allowed the appeal filed by the assessee by order dated 21/5/2019, which was affirmed by the tribunal. The tribunal has also noted the decision the CITA had also noted the decision in the case of the Gujarat, I think. Citation is not there.
My lord, it's General Motors India Private Limited.
What is the citation?
General Motors India Private Limited versus DCIT.
He's written Supra, but
There is no
citation is
Supra.
not.
I rightly noted the other decisions of the High Court on the set point. Thus, we find no grounds to interfere with the order passed by the tribunal. Accordingly, appeal fails dismissed. Next.
Item number 7.
I am appearing in this matter.
Respondent, sir.
Respondent.
This is within time.
Oh, it's coming up. Let us see the questions.
My learned friend is very keen to do this
At page
matter.
10,
Madam. May I?
Single bill composite manner. We'll admit it. The appeal is admitted on the following substantial questions of law. Page 10 and 11, 1, 2, 3. Then you shall order, sir. Next.
I'm grateful, ma'am.
Item number 8.
This is my application, your lordship.
Question. My lord, I am not briefed. Hemant Tiwari, one advocate, my lord, he was
It's for the
present.
respondent. The
He
respondent.
requested me for not today, my lord. I cannot. I have no idea. He was present up to 12 o'clock. He has some personal difficulties with him.
Question of Lord, page 8, my lord.
263.
263, yes, your lordship. But the issue of the assumption of the jurisdiction under section 263 is the challenge before your lordship. And apropos, the facts of the case is that the SSC already filed its return, and then subsequently it was taken up for the scrutiny assessment, your lordship. Now, there were some donations made to 9 companies, your lordship, out of which 3 was found to be untrue. And in respect of those, the principal CIT has held that in respect of there was no proof of payment, and the 80G certificate which was there, it was not in the assessment record. So it was the genuineness of the proof of the payments and with inclusive of that certificate, that is very much, it's a mandatory requirement for issuance of that certificate is a mandatory requirement. Now, if your lordship kindly comes to the 263 order once, my lord. From the order itself, it speaks of that if your lordship kindly comes to page 18. Paragraph 2. On perusal of the assessment record of the SSC, it was observed that the test check of the assessment revealed that the SSC claimed deduction under section 80G to the tune of rupees 3,81 and donated to 9 private charitable trusts. And from the online verification, it is noticed that the 6 out of 9 trusts are genuine, and the 3 to whom the donation was 95 lakh claimed to have been found untrue. Even 80G certificates and the proof of payment of the donation are not found in the assessment record. To claim the deduction under section 80G, certificate from the donee and the payment evidence must be obtained by the assessing officer while allowing the same. The AO, without getting the aforesaid documents and without verification of the genuineness of the donation, allowed the deduction under section 80G. Furthermore, it is found that the contribution of rupees 6 crores to 4 charitable trusts, namely the Swarin Foundation, Vishnu Trust, and Jashiri H.B. Bhudia Charitable Trust, was made, and no certificate under section 80G and the payment proof was found in the assessment record. Hence, the claim of the deduction under section claim of deduction of rupees 3.76 was required to be added back to the total income, which will result in the tax effect of 1 crore 30. Examination of the assessment record revealed that the SSC company paid commission of 4. So this is a different issue altogether, but the entire 263 is under challenge. But the main, we are harping on the issue of the 80G certificate and without the proof of certificate. Because if your lordship kindly
Three issues. 3 issues.
3 issues.
Tribunal says.
Yes, my lord.
Tribunal has examined the facts.
Yes.
In para 7, page 38,
Yes,
the
my
tribunal
lord.
says, we find the 3 issues in the present case are purely on facts, which
Based
are
on
verifiable
facts.
from records. Examination verifiable are placed in the paper book also reveal the correct state of affairs in respect to the issues raised in the impugned revision proceedings. The learned the DR could not bring any material on record to controvert the verifiable factual position.
But if your lordship kindly comes to page 31 once.
Yes.
The last the penultimate page
Yes.
31, the penultimate paragraph, there's 3.1 on the first issue relating to the claim of the deduction under section 80G of the Act for the donations made by the SSC to the 9 different charitable trusts. Learned Counsel submitted that in the show cause notice, it is stated that the 3 trusts to whom the donation of rupees 95 has been made are found to be untrue. However, no detail has been provided in respect of which all 3 trusts have been found to be untrue. On the allegation of learned principal CIT that proof of payment of the donation and the certificate from the donees for the donation made or not found in the assessment records. Learned Counsel referred to the above-mentioned pages in the paper book wherein it has been categorically noted that the money receipt as well as the 80G certificates were filed on 1st of March 2019. The date is very much important, my lord. Before the learned AO, and the same were resubmitted before the learned PCIT on 7/3/22. Learned Counsel also referred to the Schedule 80G of the income tax return, from wherein the details of the donations entitled for the deduction under section 80G are to be furnished. In the said schedule, name and address of the donation, PAN of donee, amount of the donation, eligible amount of donation, entitled for the 50% donation, without qualifying the limit has been duly furnished. This is placed at the page 40 of the paper book. In respect of the observation made by the learned PCIT relating to the 4 charitable trusts, namely the Foundation Vishnu Charitable Trust, Jashidi and HP Woody, a trust for which it was alleged that no certificate under section 80G and the payment proof is found in the assessment record. Learned Counsel referred to the relevant documents placed in the paper book. In respect of the Swan Foundation certificate issued by the Commission of the Income Tax Exemption, Kolkata, under section 80G5 clause 6 of the Act, has been given an approval which is valid in perpetuity, that is with effect from 30th March 2015, unless specifically withdrawn. This certificate is placed at page 134 of the paper book. Similarly, for the other 3 donors, Learned Counsel referred to their respective certificates issued under section 80G and the money receipts. For these 3 trusts, that certificate stated the validity which expired prior to the relevant under consideration, and to this effect, the Learned Counsel referred to the circular number 7/2010 dated 27th of October 2010, issued by the CBDT, giving the clarification regarding the validity of the approval issued under section 1023C and the 80GF G5 of the Act. In the last para of the search circular, it is stated that any approval under section 80G5 on or after 1/10/2009, this is also very important, my lord, would be one-time approval which would be valid till it is withdrawn. The relevant extract from the said circular is reproduced. May I have hand up a copy of the circular, my lord? May I be excused for only handing up only one copy? Your Lordship kindly takes up the internal page 4. This is for the removal of the doubts, my lord. It appears that some doubts still prevail, the last paragraph. It appears that some doubts still prevail about the period of the validity of the approval under section 80G subsequent to 1/10/2009, especially in view of the fact that no corresponding change has been made in Rule 11A4. To remove any doubts in this regard, it is reiterated that any approval under section 80G5 on or after 1/10/2009, for the sake of argument, your lordship, even assuming but not admitting that they're saying it was there in the file in the month of March 2009. So they can only avail the benefit of this only if it is issued on or after 1/10/2009, my lord. Because here they are saying that in paragraph page 32, my lord, that however, it is Learned Counsel referred to the affirmation pages in the paperwork wherein it has been categorically noted that money received as well as 80G certificates were filed on 1/3/19. But even for the sake of argument, if it is there, when was it given? When was it withdrawn? But that has to be indicated. It was not there in the assessment record.
But it was produced before the tribunal.
Produced before the tribunal, but the
Tribunal can
PCIT
always-
didn't have any idea about it, your lordship.
No, if you see.
Because they are.
No, it's not that way. If you see 263 order, page 19, para 4 is the response of the assessee to the show cause notice under 263. See how they say. Last paragraph. We deny the observation of AOs not obtained the proof of receipts of donation and certificate to all 9 donees for eligible donation under 80G. AO specifically asked for details of donation, examine the deductible under 80G, why it is notice under 142(1). AO would occasion to examine the details with name, address, PAN of donee, institute, trust with eligible certificates as submitted and appearing in the income tax return, schedule 80G mandatory. Thereafter, the details are sought during assessment proceeding 2 occasions. Assessee had filed the entire set of documents such as proof of payments, eligibility, etc. Copy of the letter filed in response to the notice of annexures on 1/3/19 is submitted. Impugn notice also is filed. To recollect the matter, we state that we have donated a total of 763 during the year for various causes, which such as support to government-run schools, hospitals, old age homes, and so on. The same are summarized particulars are as follows.
But if your Lordship kindly comes to page 24 once, that is the finding of the CIT, my lord, that in
He
respect
says
of,
he has not examined it.
yes,
Tribunal has examined it.
and it was, when was it withdrawn? That was also not known to them.
That is
Because
not
it is the
required.
last paragraph, in respect of the issue mentioned, the SSC submitted a list containing the name. And the Xerox copies of the certificate seems duly approved by the appropriate income tax
That
authority.
is why the
Tendering.
tribunal refers to the circular, saying that it is
Yes,
deemed to be valid.
yes,
And
relying upon that circular, my lord.
every year you can't be asking for a certificate.
Yes, that is why for the removal of the doubts and everything, your lordship, that was in a one-time approval.
That is why your counterpart there could not controvert any of the factual material.
That is why, the tribunal's finding was that it's totally based on facts.
Please come. This appeal filed by the revenue under section 260 cap A of the Income Tax Act 1961 within bracket the Act is directed against the order dated 22nd November 2022 passed by the Income Tax Appellate Tribunal B Bench Kolkata in ITA number 261/KOL/2022 for the assessment year 2017-18. The revenue has raised the following substantial questions of law for consideration. Page number 8 of the stay application. Question A, B not required. Question C, D not required. We have heard Ms. Smita Das, and Senior Standing Counsel, and Mr. Prithu Dorial, and Senior Standing Counsel for the Appellant Revenue. And
Yeah, I've given the slip.
And Mr. So-and-so, and an advocate appearing for the respondent. The short question involved in this appeal is whether the Principal Commissioner of Income Tax Principal Commissioner of Income Tax, Kolkata 1, was right in assuming jurisdiction under section 263 of the Act by passing an order on 24/3/2022. On perusal of the order passed by the tribunal, we find that the tribunal has examined the entire facts on all the three issues which were pointed out by the order passed under section 263 of the Act. After being satisfied that a thorough inquiry had been conducted by the assessing officer, the tribunal held that that the assumption of jurisdiction under section 263 of the Act was not in accordance with the law. Pertinently, in paragraph 7 of the impugned order, the tribunal points out that the three issues in the present case are purely on facts which are verifiable from the records of the SSC. Further, the tribunal states that the examination and verification of the records as placed in the paper book also reveal the correct state of affairs in respect of the issues raised in the order passed under section 263 of the Act, and that the department could not bring any material on record to controvert the verifiable factual position. Thus, we find there is no question of law, much less substantial question of law arising for consideration in this appeal. Accordingly, appeal fails, dismissed.
Yes.
Next.
Item number 9 and 10.
For the respondent in this matter, appearing with Mr. Ditoria.
Make this lodge. So all regarding the invocation of section 14A, associate offered an amount for disallowance. So basically a manufacturing concern.
Why tribunal dismissed?
No, the tribunal followed its previous orders. The previous orders, the revenue came in appeal, and the assessee with the leave of the court has filed cross objections in those matters, where this question has been raised. And here, a mere look at the assessment order will show that he's not really,
and what happened to that earlier order of the tribunal that has been set aside?
No, those are pending because the assessee filed cross objections in the revenues appeals, raising this 14A question in the earlier years. So those.
Oh, that is page 360.
Yes, page.
No.
That is one of the years. No, that is assessment at 1011, 360.
Question number 2. First is 80 IAA.
Yes,
second is Rule 8D.
That is the revenues questions. And what kindly seen that same order, my lord, at page 361, if my lord's please see leave was granted.
Question proposed in for para 14D of the affidavit, Mr. Ketan points out is not admitted by this court and another appeal concern.
Well, page 361.
Ah,
The next page, my lord, towards the end, leave is granted to respondent to file cross objection by 31st March 2020. And the cross objection is at the next page, my lord, 362. And those questions in the cross objection at page 364, my lord. 363, 364.
but which was the decision which was followed by the tribunal?
No, they referred to 1011, which is the
Assessi's own case.
Assessi's own case, and the 1011 in fact followed not 8, 9, 9, 10. Assessi's own case again. So not there again, the assessee is there in cross objection in the revenues appeal. So the question is before my lords in the earlier years. So the 8, 9, 9, 10 the cross objection is at page 342, 344 are the questions.
Page number to please.
But how does the tribunal get over this max of that?
They have not really.
What is it? Kesoram.
Kesoram. My lord had considered all these, and we cited Kesoram before the tribunal in this
Tribunal
case.
didn't note it.
It has noted it.
But because 910 went against
Yes,
you,
so therefore they said,
then we'll club all the matters, we'll hear it out.
Lordship.
Yes,
And give all the numbers.
But the numbers are with me.
I may appear.
You just, your
I will
junior
write down
can,
the numbers.
can give. We have heard Mr. J.P. Ketan assisted by Mr. Gomik and Smita Daste Prutudoria. Appeal is admitted on the following substantial questions of law. Page 16, 17, 3 questions. Then you shall order, sir. A paper book is required.
On these papers, it can be done.
This appeal can, it is submitted by the learned advocates on either side. That the appeal can be disposed of on the available papers in the stay application. Therefore, the filing of informal paper book is dispensed with. Let the appeals be listed along with. The problem would be.
The years. But if my lords are pleased to assign these matters.
That can be dragged here or this can go there.
Because not the revenues appeal will have other questions also. Assessee's appeal and cross objection are limited to this.
So therefore, it's better this goes along with that or whatever you say.
These are covered questions, not either way. So my lords can decide it. Not.
As
10
your
minutes
lordship
it
pleases, yes, it won't take much time.
But probably the other questions you will have to argue. 80 IA 6.
Because I need to check whether we are both are appearing in those matters or not. Who are the councils
Doesn't
engaged? Again, that those needs to be tagged and we have to find out and ascertain who are the councils.
Let the appeals be listed along with. No.
Problem.
No, if it is, we say that, say it will be, note will be replaced to me, then I have to pass it. Then you strike out that and say, since the since the questions of law in this, the questions of law which have been admitted for consideration are arising in the cross objection filed by the assessee in an appeal filed by the revenue for the earlier assessment years. And since this is a substantive appeal at the instance of the assessee, we are of the view that the other appeals which are pending before this court should be heard along with this appeal. Let the matter be placed before the Honorable Chief Justice for appropriate orders.
But the next matter, except for that amount, the figure, the questions are the same.
Item 10 also same order.
The figures should go down correctly. That is all.
Figures will in the question of law, the amount mentioned will be different. So you have to see the question and then.
I'm grateful.
Afternoon, appellate side. Election.
My lord, may I have your lordship's kind leave, lord, to mention one new contempt application.
Yes.
Lord, this is arises out of your lordship's order. The Honorable Chief Justice sitting with Honorable Justice Hiranmaya Bhattacharya. Lord, this
You please
relates
give-
to, Lord,
You please
supply
give,
of a new connection.
you please give the number.
Yes.
Probably next week, I think Justice Bhattacharya will be here. Will.
Lordship, mine is a contempt appeal. Matter could not be taken up because other side prayed for time. Now it has gone to the bottom of the list.
We'll upgrade it though. But
Yes,
twice.
Lord.
they took-
23rd is the date, Lordship. Last week, we tried twice. 2 days, the matter could not be taken up. Once there was a shortage of time, Lordship heard and passed a short order. Next day, other side take it
Tomorrow.
tomorrow. At the top, Lordship, if
You
you,
inform the other side.
Lordship, I will do.
Because they shouldn't be taken by.
I will. I must oblige.
Yes, please call the list.
Affiliate side, daily list, serial number 1. My lord, on the last occasion, a leave was given to file a supplementary affidavit. My lord, I have served copy. Now, my lord, the matter arises here. There was a, my lord, specification, which is version 3 of the specification.
What specification?
My lord, it is the RDSO, that is the Research and Development Wing, gives certain specification for certain, my lord, multi-section axle digital counter. What are these, my lord? This is the basic of Indian Railway safety system. My lord, if my lord kindly takes 1 page of this first volume, my lord will find that there is a diagram also at page 98. This is, my lord, the multi-axle digital counters. The heart is, there is a central evaluator, my lord, and through this, sorry, page 98.
Page 98 is not here.
The volume 1. Can 1. No, this is memo of appeal problem. I will read the.
This is can 2.
Can 2. Can 2 is filed by my learned friend. The heart of the matter is
Can
this.
2 is an application for perjury, saying that my learned friends have blatantly lied to the court in the stay application.
But I will deal with that. I will deal with that, whether it is lie or not at this stage, and why they say I have lied, my lord, my clients have lied, I will definitely indicate. Page number 98. My lord, the document starts from page 87. This is of some importance, my lord. 87, the document starts. This is, my lord, the specifications. Research Design Standard Organization, Lucknow, my lord. Multi-section digital axle counter specification number RDSO SPN 176/2013, version 3. This is important, my lord. This consists of 29 pages. And my lord, what is a multi-axle digital counter? That is explained in page 95, my lord. That clause 4, multi-section digital axle counter system comprises of axle detectors, DAC, that field units, that is digital axle counter field unit. Then, my lord, central evaluator, reset unit, relay unit, event lodger, and diagnostic terminals. Multi-sectional digital axle system should be scalable and support, my lord, this is important, detection point and generate vital replay outlet for requisition track sections as per the user requirement. Now, my lord, what is this? Now, a diagram may help here. Kindly come to page 98. This is a central evaluator, one central evaluator connected with various detection points. See, my lord, first is DACFU means, my lord, digital axle counter field unit. But it has seen, my lord, track side, digital track unit 1, track unit up to 8, track unit 33, and then, my lord, will find track unit N. What is N, my lord, has been explained here. Kindly take, my lord, page 101. 4.4.4, the central evaluator shall be able to connect up to 40 detection. Sorry, 5.5.4. Sorry, my lord. 101, page 101. Central evaluator.
Yes.
Central 5.5.4. Central evaluator shall be able to connect up to 40 detection points, and 5.5.8. Central evaluator shall be able to generate relay output up to 39 track sections. So what is there? My lord? There are detection points in a rail track. These will count the wheels. How many wheel goes in, how many wheel goes out. If the matching is same, then the track section is clear, then another train can come in. Suppose, my lord, a bogie comes in, goes out. Now, if there is a mismatch, then it will show as occupied. Suppose, my lord, instead of counting wheels, they count axle counter. Or suppose, my lord, they count the chains. Then, my lord, they will show occupied, whereas the train is not occupied, the intersection. Or else, otherwise, suppose a train is occupied. What has happened in Balasore, my lord, the goods train was occupying a particular track. This has been shown as clear. That's why the train coming from Calcutta side has bumped into it.
Well, that is
Now,
not the Balasore.
Malad,
Balasore bogie should not be raised.
No, no.
Well, that is a human error. That is what's being reported.
No.
We'll come back.
Yes. Now, grasp of the matter is, my lord, that this functioning has to be very clear out of this detection point. Now, after this, what happens is, my lord, that suppose there is it shows occupied or it shows certain malfunction, we have to reset the button. There has to be a reset. Now, my lord, there are two types of reset. One is preparatory hard reset and one is, my lord, conditional hard reset. If my lord kindly comes to page 92 once, my lord.
Yes.
My lord, kindly see terminology. Axle detector, the track device comprising of coil fixed in the mount cover on the rail. It will detect the wheel passing over the device. This is the axle detector. How many wheels passes? Now, next. Then, my lord, detection point. Thereafter, counting device. Counting device, digital axle counter field unit in the track side electronically assembled that energizes the axle detector for detecting passing of the wheel, determining the direction of the movement and keeping the count of the wheels. It transmits the count and health information. Then, detection point comprises of one axle detector and one field unit connected to it. And then, my lord, resetting. Resetting commands are setting 0 the records of counting axle. Here, there are two types of resetting. One is preparatory reset. After resetting, axle counter shall continue to show occupied until one train moved in the section carries out balancing the track section. This is, my lord, like a, if I may use that expression, my lord, a guinea pig. The first train going, and the other one is, my lord, conditional hard reset. The reset is activated after physical verification of the condition from different locations like clearance of the track section from the site unit, line verification, axle counter shall show clear after conditional reset. Now, my lord, kindly see page 98 I was showing. Kindly come to page 99. There, I will only consider two clauses, 5.3.7 and 5.4.3. It says, my lord, the axle detector shall be actuated only by wheel flanks and not by any other parts of the trains, such as rail brakes, toilet pipes, suspended chains, electrical inductors in locomotives, air conditioning equipment, and other electric equipments in the train engine. So, it will only count the wheel, my lord, and nothing else as per this. And 5.4.3, my lord, this is important. Track section wise resetting shall be easily configurable as per preparatory reset or hard conditional reset. What does this mean, my lord? That one evaluator can configure both preparatory reset and hard reset. Because where hard reset will be applicable and where preparatory reset will be applicable, that has also been considered. only one more thing, my lord, 106, 10.3, the axle counter's service life shall be not less than 20 years. So for when you supply, it should carry on for 20 years. This is the pith and substance of this guidelines or the specifications. Now, my lord, may I, my lord, request my lord to take this supplementary affidavit once, my lord? I've given them a copy. This is all admitted documents. Supplementary affidavit, kindly, my lord, straight away come to page 31. 31. একদম ভুল বলছি একেবারে kindly come to page 9. Sorry, page 9 of the supplementary affidavit. Why I'm showing this page, my lord, just there's a type of clerical error in annexing documents. Kindly see the date is no, sorry, yes. Kindly see the application form, my lord, of the petitioner, 8th of February 2018.
Yes.
They have, my lord, with reference to the above, this is vendor registration number. Hard copies of the application submitted and other documents for vendor registration. My lord, this is the first page, this is the second page, and this is the third page. In the stay application, unfortunately, my lord, the clerk has attended from the third page. Kindly, my lord, in this context, my lord, kindly come to page 116, which is the application of 8th of February. Here, this is the application. They have said, my lord, on this basis of the application, that they will do something or the other. What they do? Kindly see, first of all, my lord, page 120. The clause was 501. Multi-section digital axle counter consisting of axle detectors and field units, scalable up to the requirements. Now here, what is the saying, my lord? Complied BO23 is the name of the evaluator. Unit consisting of indoor unit, outside unit. Outside unit consists of axle detector. Then, my lord, one BO23 support up to 8 detection point and 6 track section. More evaluator is cascaded arrangement in support of DP and 39 track section as per the user requirement. Now, what are they saying? I have shown, my lord, detection point was up to 40. So they are saying they cannot cater to 40 detection point. They will cater up to 8 detection point and 6 track section. This deviation they have paid for. Now, my lord, thereafter, kindly see 5.0.5. Axle counter shall have arrangements so that wheels and push trolleys, dip trolleys are not counted by the trolley protection track section. Here they say complied wheels of push trolleys, dip trolleys are suppressed. Then straight away, my lord, kindly come to the clause of 5.0.9, the diagram. Here they have said, that is at page 124. A 5.0.9, my lord, noted and complied. So they consist, this shows only one evaluator. I am insisting upon this phrase repeatedly. Then, my lord, kindly come to 5.3.7. Here, my lord, will find page 125. Axle counter shall be actuated only by wheel flanks and not other parts. It says compliant. And 5.4.3, my lord, at page 120, track section wise resettings shall be easily configurable as preparatory reset or conditional hard reset configurable. They don't say, my lord, 2 or 3 or 4. I am insisting, my lord, and now kindly only last, so far as their compilation is concerned, page 128, my lord, kindly see 5.5.3. sorry, 5.3.4. Central evaluator shall be able to connect up to 40 detection point, my lord. Central evaluator on the left hand side is our specification. They say compliant and configurable 7B023 can connect up to 40 dp. That means 7BO02. Seven evaluators can connect up to 40. My lord, if I take 8 DPs to connect, then 40, my lord, 6 is enough. Because why 7? Because when 8 detection point 1 evaluated.
Yes.
Then my lord, 6 detection points is 42. 6 evaluators is 42 detection points. I have to cater only 40. I could have catered with 6. But why they said 7 is because track section they can only cover up to 6. That's why in 5.5.8 they say central evaluator shall be able to generate that is page 128. 39 track sections, they say they need, my lord, 7 evaluators because they can carry up to 6. So for 40, they need 7. That's why they said we need 7 evaluators to cater 40 detection points.
Yes.
Now, based on this application, my lord, we have granted them fresh registration. That is page 147, 26, 2019. Here,
yes.
Kindly see, my lord. This is Sigma. The modified approval letter based upon the submissions of the requisite and indigenation plan in compliance with the cross-approval policy. What have they granted, my lord? Kindly see. I was multi-digital axle counter, my lord, UNN model BO23 version 2.3. This is the evaluator, my lord, I was insisting upon. And this is being manufactured by Croatia, my lord. Alpro Croatia, they are only importing it. They are not the original manufacturers. And kindly see, my lord, the specification is RDSO 17176 version 3. This is the specification on the basis of which I will require to check. And kindly come to 149, my lord. Clauses 26 and 27. RDSO reserves the right to inspect this product at any premises where it is in use or at the place of the manufacturer. If any deterioration of performance of the approved product is noticed during use, RDSO reserves the right to cancel the approval as per the procedure laid down, and product shall meet the requirements of the specification unless specific deviation is granted. Now, the only deviation that was granted was one evaluator should cater 40 dp. Instead of that, one evaluator of yours will cater 8 dp and 6 track section. This is the only deviation granted. Now, my lord, and one thing, when this 147 speaks of, my lord, kindly see cross approval policy. Farm approval letters not allotted due to cross approval. My lord, after 5, my lord, will see this. What is the cross approval policy, my lord? They say a product is being operated in Croatia, I am importing it, but there has to be certain criteria, my lord, for adoption upon the Indian railway systems. Those 2 criteria are, my lord, kindly see 156 once. Safety case along with assessment by an independent safety assessor and certificate by, it should be, my lord, independent safety assistance is required.
Which clause you are reading?
My lord, this is cross approval policy, page 154, it starts 156. 5 point, because I have insisted upon these 2 clauses only. Safety case along with assessment by an independent safety assessor and certificate by an independent safety assessor to require the level. And then, my lord, turn over the page 157, 12, clause-wise compliance statement to the existing RDSO specification and statement whether the system is suitable for Indian Railways application or will require modification. This they have to supply. Because they can't just import automatically. They have to satisfy that this is applicable to Indian conditions. Now, my lord, up to this is the facts on record. They say that they have supplied 69 times, and this 69 times they have been, now here, what is important? They supply, my lord, the MSDSC, but payment is being made on detection points. How many detection points you supply? On that basis, payments are made. Now, they say 69 times I have supplied detection points. You have approved. This time you are not approving. And your reason for disapproval is insistence upon a clause in the specification, which is also there in ATP. I will come. Acceptance test format, they say you have applied acceptance test format. 69 times you have given. Now 70th time you have to give by acceptance format, but not specification. Now, admittedly, if I apply this specification, they don't comply. Why I say admittedly? Because I have shown, my lord, the clauses. There is no statement that for 8 detection points, I need 2 evaluators. Nowhere. I say one evaluator can cater up to 40 detection points. They say no. One evaluator, I will cater up to 8 detection points. For 40 detection points, I need 7 evaluators. And I have shown the mathematics, my lord. 6 would have been enough because of the tax section. They said 7.
Now you cancel the registration.
No, I have, well, cancel registration will come later. I was inspecting a particular product. I found out, I'm showing my lord the 2 documents, where from it will appear, and see the way the Honorable Judge, my lord, with all humility has interpreted it.
What was impugned in the writ petition?
Writ petition, my lord, there are 3 things impugned. One is the cancellation of the 70th inspection. This is one. Number 2, the railways letter that you have to have an independent safety assessor certificate, and in the fact that the materials are suitable for Indian conditions. 2 documents, my lord, I will show. One is the letter of 2nd of January 2023. That is volume 3, my lord. Can you see volume 3? (390). Inspection document. Well, before I go to volume 3, on volume 1, well, just 2 other pages, my lord. 172, if my lord kindly comes. This is impugned and this has been set aside.
Okay.
Here it says, my lord, 9th of November 2022. This is a non-conformity report, my lord. This has been signed by Ashok Kumar Mondol on 9th.
Yes.
Now, Ashok Kumar Mondol signs on 9th, my lord. That, my lord, will get at page 174.
This reason for rejection is
does not comply with 5.4.3 specification of 5.4.3, my lord, at page 99, my lord, kindly come once. This is, my lord, it is easily configurable. 5.4.3, track section wise resetting. There are 2 sets of resetting, page 99. page 99, my lord. Track 5.4.3 track section wise resetting shall be easily configurable as preparatory reset or conditional hard reset. One evaluator in their case is not doing this. This is an admitted position. So I say, my lord, it's not doing because when my lord is 199, sorry, my lord is saying page 129. If I may request, my lord, kindly make a note, my lord, of page 126, because for 5.4.3, they have said that it is configurable at page 126. They say they can do it. They did not say that it has to be on 2 evaluators, so far as 8 track section is concerned. Now, my lord, now this is interesting because why I'm showing you, this is, my lord, kindly see page 173. My lord, Narayan Mukherjee has signed on 10th of November. Because Honorable Judge was very caustic. It says it's a predetermined day because inspection was taken on 10th and signature was made on 9th. That's why I'm taking my lord's time.
173.
This digital signature, my lord, has seen, my lord, 10th of, this is not 9th, of Narayan Mukherjee is, my lord, 10th of November 2022 at 12:20 IST. And the inspection is, my lord, at page 175. Kindly see, my lord, Narayan Mukherjee's name is first. The track section wise resetting as preparatory or conditional reset is not possible with evaluator, spelling is wrong there, but single evaluator 5.4.3. This is on 10th. Honorable Judge said that on 9th you have issued this at page 172 and you are taking inspection on 10th. That means it's a predetermined illegal thing. I have pleaded this, sorry, the clients have pleaded this. From 7th to 9th, inspection was taken by a junior officer by the name of Ashok Kumar Mondol. That is matter 172.
Inspection from 7/11 to
9th. Now, 9th, he has said that it is not being complied with.
Yes.
Narayan Mukherjee went personally on 10th to see whether exactly this is happening or not, because this is...
Who's Narayan Mukherjee?
Narayan Mukherjee is respondent number 3, applicant number 3. He is the head man, so far as this research development team is concerned, of Indian Railways session in Calcutta. Beyond him, there is no one in Calcutta. Lucknow is there, but Calcutta, he is the last man. So he personally went to recheck it, and on 10th, the Taposh Gayan has not refused to sign of the writ petitioner, but he found that it is not possible with a single 10th. Honorable Judge commented that the report is on 9th, thereafter you went, and on 10th you have done this, so this is absolutely malafide.
So your case is, whatever Ashok Kumar Mondal was certified, this Mr. Narayan Mukherjee had verified it on 10th.
And then this
issued. And what did he do after verification?
After that, he digitally signed on 10th.
Digitally signed which document?
But the document at page, the document of communication to the petitioner, sorry, to the writ petitioners. The document of communication to the writ petitioner was
so page 1, according to you, page 172 was certified by Mr. Narayan Mukherjee on 10th November.
Malad, kindly see page 172.
Yes.
There are 2 digital signatures on the top.
So the bottom it is signed by Ashok Kumar Mondal.
Ashok Kumar Mondal, left hand top, my lord. Kindly see 9th of November at about 18:25 p.m. my lord. That is Narayan, that is Ashok Kumar Mondal has signed on the top.
On the left side.
Yes.
On the right side, it is
Narayan Mukherjee has signed on 10th,
10th.
not 9th. Now the Honorable Judge was, I will show the impugned Honorable, has chopped our head. Because this is a predetermined manner. On 9th, you have signing this, and on 10th, you go to inspection and do this. Atrocious.
Now, what is the direction issued?
No, direction issues, manner, we will have to be a rubber stamp.
No.
Yes. Direction.
Now, this order has been quashed.
No, this order has been quashed. So the direction, mandatory direction is, I have to only comply as a rubber stamp They are all products.
No.
I will show why.
What was the, you said there is some urgency, 7 days it has.
Yes,
to be-
yes, 7 days, my lord,
has to
then
be done.
they moved in contempt.
What has to be done in 7 days?
My lord, I have to inspect the materials and give them the order of approval.
Let us see the operative portion of the.
Yes,
direction.
before that one, only one further document, my lord. Why this? Because this is one document they have challenged.
So this is the sole ground on which the order has been set aside.
No, there are other, there are two other grounds. First is, there is another document, after this, I have said, my lord, you take corrective measures. Kappa, corrective measures you take. There are a bunch of documents, my lord, from 352 page to 357. Every time we have, for 17 times we said you take corrective measures. They did not. Now, thereafter, on 2nd of January 2023, that is the document which I was showing, my lord, page 390. We said, in the meantime, my lord, there's a complaint made from the Vigilance Department. I will come to that. We only insisted on two things. That is, with ISS certification, my lord, I have shown the clause, and my lord, that it is suitable for Indian passengers. That is 2nd of January 2023. That is at page 390.
No, let us go to the order which is impugned in this appeal. Order passed by the.
Yes, yes, certainly, my lord. I was only showing one or two more.
No, after that, you please show us.
But
now, this is one of the grounds on which the order was set aside.
yes, yes, they say they were supplying two evaluators. Kindly see the impugned order. Memo of appeal also contains that, my lord. May I just place the order, my lord?
Accordingly allowed and disposed of, cancelling the report dated 9/11.
Yes.
Alleged joint report dated 10/11. Respondents 1, 2, 3 are accordingly directed to commence the inspection within a period of 7 days. So a re-inspection has to be done.
Re-inspection has to be done.
From today, in accordance with specification framed by so-and-so and ATP, applying the identical procedure for testing inspection with the same frequency as was being done in the 69 prior occasions before the impugned documents dated so-and-so shall be inspected by RDSO and so-and-so within a period of 7 days.
So 17, this order is passed, my lord. We have to do it within 7 days. Now, what is this urgency? Why is this urgency and why we are frightened? We are frightened. If we do it by way of a specification, then they don't comply because they themselves said now that they will supply 2 evaluators and not 1 evaluator. We say that 1 evaluator has to comply both preparatory research.
That stage is gone. You have scrutinized his application. On evaluation, you have granted his registration.
Absolutely.
Which you have just referred to.
Yes.
In page number where is that?
147.
Page 147.
Yes.
It says, based upon your submission of the required performance guarantee in this also, compliance of the cross approval, competent accorded cross approval to all the included so-and-so.
And this is in respect to the specification number RDSO 176.
So this registration was granted, fresh registration.
Yeah.
This is valid for how many period? What is the?
But this is now valid unless cancelled. This is, my lord, valid. I will take the instructions now. This is on this basis, while we are doing it, this is valid.
So until it is cancelled, it is
more or less, I will take instructions.
Now you are free to do the inspection, whether it's satisfies the model requirement, etc. specifications. In that inspection, according to you, the specifications have not been met. But can you fall back on their representation in their application?
Yes.
The application was scrutinized.
Yes.
And found to be correct, registration granted.
Yes.
Post registration, if the signaling system is not working properly, or there is some defect which he has not rectified, then there may be a show cause notice you can issue.
No, yes. No, this is I registered on a basis of a paper that they will supply this. After this, they are supplying.
So you found it to be not as per specification.
Absolutely. This is the point. When they promise, it's a question of promise.
Now the learned judge has only directed inspection.
Directed inspection in the same manner as of 69 times. I say, my lord, so far as the specification is concerned, that they are not complying. See, today.
Then you could have cancelled the registration.
Yeah, well, we are in the process of, it was interimly stayed. My lord, it was interimly stayed. The first order was not to take any other steps. I can cancel it, but today kindly see. I can cancel it. I have to give them the opportunity to rectify. I gave them the opportunity to rectify. Today, they have not rectified. I was in the process. That's why the writ petition was filed. Today, if I do it.
No, where is the inspection you have done after their rectification?
There no rectification done.
All right, where is the letter asking them to rectify?
Yes.
See, you can't have you can't have an inconsistent case.
No.
Very simple. This is the equipment to be supplied. You have got your specifications. On the basis of his representation, you granted registration.
No, not
on the basis of his representation.
No, only on paper representation.
Correct,
This is
paper,
important.
that's paper representation.
Yes. Now they
not representation, application.
Application.
Based on the application, you granted registration. Now you find that it is not as per the specification. Or is it not working as per the specification?
Yes.
There are two things to it.
Well, there are both. Here, both is appearing.
We have got another division bench at 3:30.
I may only pray for because
the train is not at all moving, sir. What to do?
Malad, they are proving in contempt, and if we do it, Malad, we will.
30,000 is nothing for you.
No, well, let them not further proceed with the contempt. I'm coming back on tomorrow, Malad, because cost.
We will continue the matter. Now,
Personal appearance is given, Malad. Cost of 30,000. Cost of filing affidavit is 30,000.
Your affidavit is ready.
No, well, affidavit we will make ready within 2 or 3 because of the depending upon this.
The matter is coming tomorrow.
Battery, I have to deposit. I prayed for.
No, matter is not coming. It's
Malad,
coming on the 7th of July.
No, I have to pay cost within tomorrow. Otherwise, Malad, and personal appearance.
We can extend, sir. There's no problem.
Very good.
Ultimately, we decide against you. We'll add one more zero.
Very good, Malad. That's entirely up to my lord because we are.
No. The thing is, it's very simple, sir. There are one thing to say that this does not match the specification.
Yes.
That is point A. The another thing to say that it doesn't give the desired result which is required in terms of your invitation of tender or whatever it is. But if you say in the first point, it doesn't meet the specification, question of rectification doesn't arise.
But may I only pray for
Rectification can arise only if you qualify and there is some discrepancy. So one addition to be made, one deletion to be made. If the whole product doesn't match the specification, he is out.
Yes.
Then why did you ask him to rectify?
Because as has fallen from my lord, there are two parts of it. One is the product doesn't match. Right.
Correct.
So what we said, please resubmit the product.
Page number?
Page number is 532.
Volume 3. 532 must be volume 4.
532, my lord. Corrective and inspection call number so and so is rejected. Kappa needed. Kappa means corrective and preventive action needed. Please resubmit. So, my lord, I am asking them to resubmit the product.
They will resubmit it.
They will resubmit after taking corrective measures, my lord. Kindly see from page.
Rejected. Do you see what is the expansion of kappa?
Kappa is corrective and preventive action. Corrective and preventive action.
And sir, what as a layman we are asking?
No, sir.
Corrective and preventive action can take place if only if there is a defect. If it doesn't match, instead of an apple you give an orange, it can never be corrected.
Absolutely, my lord. Here,
so therefore, where do you say if he doesn't match the specification, correct it means you ask for replacement that is sufficient.
My lord, kindly consider. This is a very fundamental point. Why I say corrective?
All right. What is the procedure under the tender document or whatever it is. What is his remedy available?
Remedy available is to supply in terms of the specification, which everybody else
All
will
right,
supply.
according to him, the product is matching your specification. You say no. What is the remedy available under your terms and conditions?
Under my terms and conditions, I have to give him the scope to correct. If he doesn't correct, I have to cancel
And
it.
what was his response to page 532?
But page 32, there is no response. I will show the response on the finally when I said on 2nd of January, then he said that he was supplying 2 evaluators to match the specification. He said, and I will show from the documents, he said throughout 69, he was supplying 2 evaluators, paragraph 9 and 11 of the writ petition. Mathematical calculations say it is not possible. It is not correct. Their own documents will show, my lord, they were not supplying 2 evaluators. They were trying to, and the perjury application made, I will show, my lord, it was an in the old specification, they could supply 2 evaluators to cater, one preparatory, one hard. Under the new specification, it is not possible. Is
there any reply to page 432?
Yes, yes.
532?
Lots and lots of replies, continuous correspondence.
No.
And my lord, this is RDS's own stand that you can do it with 2 evaluators.
No, I will show that you cannot. Kindly, my lord, I will.
No,
it's
for
on writing.
69 times they have done it.
Not on 2 evaluators. I will show from their own records. They are now trying to, with all humility, cost, my lord, one way or the other, one will get. But at least, my lord, let us present the case admitted by them. They on the writ petition said they have supplied 2 evaluators. Mathematically, that was incorrect. I will show from their own documents. I am going to this extent of showing, and they say, very, very beautiful draft. They say, I will supply a evaluator free of cost. And in the past also, whatever I have supplied, if there is anything, I will supply free of cost. Honorable Judge was impressed by that submission, that as if, what a good Samaritan, free of cost is suffering. You don't get paid on evaluators, you get paid on detection points. You have to say for 8 detection points, you are supplying 1 or 2. There is a spare, my lord, in any supply, there will be some spares. But ignoring the spares, if they say they have supplied 2, mathematically they have to match before the court. If they can't, my lord, I have a chance to demonstrate that previously on 69 times they have not supplied 2 evaluators for detection.
May I, my lord, with your lordship,
And
just make one submission.
My lord,
This, my lord, continuous submission about so many detection points, so many taxes. That is not a part of the pleadings at all before the
it was part of the pleadings I will show, and ATP and...
Two case attempted to be argued from the bar, which the learned judge has said, this is not a part of your pleadings and this is not a part of the RDS specification.
Yes, I'm joining issue there. It was very much a part of the pleadings.
May I do this? I have prepared, my lord, a convenience compilation so that your lordship doesn't have to, my lord, tribes through 6 volumes. Well, I think, my lord, all the papers that are relevant and a part of, my lord, the records before the learned single judge are in these compilations. If your lordship, my lord, permits me to hand it over, it will be much easier to...
Subject to his consent. If he says that he has to rely upon some other document.
No, but all of these are a part of, my lord.
I have not seen the document.
You see it tonight.
Tonight.
I'll give him a copy.
Tomorrow we can continue.
My lord.
And this cost you don't insist upon. Where you have to remit the cost?
My personal appearance and cost invited. I have given.
Personal appearance is on 7th July.
No, but cost, well, kindly see, is extended till 3rd July upon cost of 30,000 to be paid within 7 days. That is by today.
Well, your lordships will extend the time to pay the cost if your lordship is satisfied that, my lord, there
But
is...
today, if I have to, that's why I've insisted. They say one day, they said Wednesday, Thursday. I said Wednesday.
Order is passed on the 17th of May. My conference filed the appeal on the 15th of June. After, my lord, the contempt application is done and the order is made.
Summer vacations were there. My lord, Union of India, my lord knows, my lord, from Lucknow, we have to take instructions. And these days, subject to correction, I would not know. First digitally, then a number, then... So, my learned friend will not take kindly.
No, very soon all your private briefs also will be like that.
No, that's true. But, my lord, on this point, let us not join the issue. So far as cost is concerned, kindly pass it.
I'm handing over to my learned friend a copy of the compilation.
Heard Mr. So-and-so, then an counsel for the appellant. For continuation of arguments, list on so-and-so. Mr. Jishnu Shah, learned senior advocate, appears for the respondent writ petition. The learned advocate for the appellant submitted that the learned single bench has imposed cost on the appellant and the time expires today. There is also a direction for personal appearance. Since the court is seized of the matter and the appeal is being heard, and due to want of time, the hearing could not continue, the time for payment of cost stands extended until further orders, and the direction for the personal appearance of the concerned official of the appellant is dispensed with for the present. List the matter
That
tomorrow.
matter is only for the 7th of July.
Doesn't matter.
Very well.
List the matter tomorrow under the head and under the same caption. You go through that
Yes, certainly.
compilation. If that is satisfied,
Absolutely, certainly, it will be convenient for both of us.
Lordship, regarding item number 4, my lord.
Ah.
My lord, I appear for the respondent writ petitioner, my lord. My lord, tomorrow, my lord, the learned senior counsel will be in some personal difficulties, my lord.
Ah.
My lord, kindly take it up next Wednesday, my lord.
next week. But who's for the?
My lord, I am for the appellant, my lord.
Oh,
My lord, I have no difficulty, my lord, only it is understood, my lord, no, my lord, my lord, construction will be raised, my lord, till the my next date of.
that I don't know how your friend won't be able to give that undertaking.
Next date of.
When do you want it? Monday?
Next Wednesday, my lord, or Monday, my lord.
Huh? Monday and Tuesday is PIL.
PIL day, huh.
Next Wednesday. And the same position.
Same position.
At the request of the learned advocate for the respondent, adjourn next Wednesday, and the case shall be listed in the same position.
Four.
Dipesh.
Appellate side, daily list, serial number 1, fixed at 3:30 p.m.
Might appear for the petitioner in this matter. This is a contempt application arising out of the order passed by your lordships not on 15th of this month. Not this is with regard to the panchayat elections, not where your lordships had been pleased to elaborately consider not the present state of affairs and not for the purpose of a peaceful election. Your lordships were pleased to direct the election commission to immediately deploy central forces. But just to remind your lordships, not may I draw your lordship's kind attention to page 34 of the writ application, which is part of the order. I'm sorry, it's page 30. But it records the earlier order. Without detaining your lordship any further on the factual aspect, if your lordships will kindly have a look at page 30, somewhere in the middle of that page, the sentence starting with the words from the middle portion of the line, it is not in dispute. It is not in dispute that a preliminary assessment has already been made by the State Election Commission, and several districts have been earmarked as sensitive districts. It has been widely reported in the press that there have been several instances where the prospective candidates complained about non-availability of nomination papers, which resulted in violence being precipitated and such other incidents. Considering the fact that a total number of seats for which the election has to be conducted is more than 75,000, and going by the past incidents wherein on more than 12 occasions, the court had to intervene for directing deployment of central forces or transferring the cases to the NIA. We are of the view that the State Election Commission should and shall requisition the deployment of central forces to work in tandem. In tandem, not I lay emphasis on these two words, in tandem with the police force of the state of West Bengal to ensure free and fair elections. It is stated that in the report that the assessment plan submitted by the state will be reviewed by the State Election Commission for taking appropriate decision. The ultimate decision should lie with the State Election Commission, more particularly when it has been the consistent submission of the petitioners that there is inadequate police force for being deployed throughout the state so as to cover all polling stations, especially when the number of seats for which elections are to be held are more than 75,000. Therefore, the State Election Commission shall forthwith send requisition of the deployment for the central forces at the first instance for all the areas or districts which in the opinion of State Election Commission have been declared as sensitive. Thereafter, the State Election Commission shall review the assessment plan submitted by the state, and wherever there is inadequacy of the state police force in all such areas, also the State Election Commission shall requisition the deployment of paramilitary forces. This requisition shall be done forthwith by the State Election Commission, and on receipt of the same, the appropriate authority of the central government shall deploy the required strength without loss of time. Considering the facts and circumstances, we are of the view that the charges towards such deployment shall be borne by the central government and no part of it shall be charged to the state of West Bengal. But this is a concession given to the state government, but more so not keeping in view not the protection of right to life. Please have a look at 38 now. After page 38, paragraph 13. After we had heard the learned, have your lordships kindly got that? After we have elaborately heard the learned advocates for the parties and carefully considered the materials placed by the Election Commission, it is clear that the State Election Commission has not taken any proactive and diligent steps with a view to implement the directions issued by this court in the earlier writ petition in its letter and spirit. We say so because in the minutes of the meeting dated 9th of June 23 convened by the Commission with the Chief Secretary and the Director General of Police, with regard to the identification of the sensitive areas from law and order point of view, it has been stated that the district magistrates and superintendent of police have initiated the process of identification of sensitive areas from law and order point of view. Though such was the decision was on 9th June 2023 till today, 15th June, such identification has not been made. This is clear from the communication sent by the State Election Commission to the Chief Secretary Government of West Bengal dated 14th June, wherein it is stated the Chief Secretary has been requested to submit assessment plan and deploy of forces for the ensuing Panchayat general election at the earliest, so as to enable the Commission to further necessary action in the matter. Thus, it is seen that more than 5 days, no action had been initiated and no assessment plan had been submitted to the Commission, which clearly shows that there is a slackness on the part of the administration in promptly reporting by identification of sensitive areas from the law and order point of view. In fact, it is the submission made on behalf of the Commission today that it may take a few more days for the identification of the sensitive areas. This, in our view, is not appreciable because of the fact that today is the last date for filing of nominations, and the next will be a crucial event where the last date of withdrawal of nomination have been fixed. Therefore, considering the sensitivity of the problem, the court in the earlier writ petition had directed the Commission to forthwith requisition the central forces. However, the matter has been dragged on, and we find that the state authorities had not extended the due support through a decision, though a decision was taken as early as on 9 June 23 for identification of the sensitive areas from law and order point of view. Therefore, we are of the view that we will be well justified to issue appropriate directions, which to our mind is absolutely essential in order to ensure free and fair elections. We wish to emphasize that a direction in this regard is required to be issued bearing in mind the electorate, the people of West Bengal who will exercise their franchise in the ensuing election. Then Lordships may straightway turn over to page 42, page 41, paragraph 16. Note, I need not trouble your Lordship with the submissions advanced and not on the technicalities of the averments. Please have a look at page 16, paragraph 16 at page 41. In the light of the observations in the preceding paragraphs, and also taking note of the fact that no appreciable steps have been taken ever since the order was passed, in the earlier writ petitions, and till date, no effective steps have been taken to identify sensitive areas from law and order point of view. And in the light of the submission on behalf of the Commission that it may take a couple of more days to do so, we are of the view that waiting any longer will cause more damage to the situation and will not aid in protecting the purity of the election process. In the result, this writ petition is disposed of by directing the State Election Commission to requisition the deployment of central forces for all districts in the state of West Bengal, and this direction shall be complied with by the State Election Commission within 48 hours from the date of the receipt of the server copy of this order. On receipt of the requisition, the appropriate authority of the central government shall deploy the required number of central forces, and the cost to be borne by the central government, and no part of it to be charged to the government of West Bengal. The State Election Commission shall issue a circular that all officers who have been assigned for election duty shall display their identity cards prominently, and whenever any of the observers or any authority calls upon to prove their identity, they would readily and immediately produce their identity card and establish their identity. With the above observation, the writ petition stands disposed of, no costs. Now, not this matter is taken to the Honorable Supreme Court. Not just to show not that your Lordship's observation had been affirmed. Kindly have a look at page 8 of the order. The last paragraph on page 8. It is relevant to observe that this is not for the first time that a direction for deployment of central paramilitary forces has been ordered by the High Court. In paragraph 48 of the order dated 13 June 2023, there is a discussion on the earlier occasions in which the High Court had directed the deployment of paramilitary forces as and when the situation so demanded. It is in the above background that the direction was issued to the State Election Commission to send the requisition for deployment of the central forces in areas which, in the opinion of the State Election Commission, had been declared as sensitive forthwith. Therefore, we find that it was directed in the earlier order that there must be identification of the sensitive districts. But this was quoted from your Lordship's order. Please have a look at the last paragraph. The fact remains that the tenor of the order of the High Court is ultimately to ensure that there is a free and fair election conducted in the state of West Bengal. Moreover, the state is conducting local body election on a single date. The High Court has also based its decision after considering the number of seats which are going to the polls and the volume of polling booths that are being set up for holding the said polls. Please keep over to page 11 now. The endeavor of the respondents appears to be appears to be to ensure free and fair election to the local bodies in the state. This would strengthen the Panchayati Raj institutions in the state. Therefore, in our view, the High Court was not in error in issuing the aforestated directions, as the same was done to ensure not only that the nominations are filed in a peaceful manner, but also that the entire election is conducted fairly and the results are declared peacefully. We also take note of the fact that the respondents herein, who were the petitioners before the High Court, although affiliated to different political parties, were united in seeking deployment of the central paramilitary forces in the state of West Bengal. Now, my lord, your lordships in the subsequent order of 15th June made it clear that the order has to be obeyed in letter and spirit. That's the last paragraph in your last few words in your lordship's judgment. Now, my lord, a show of a compliance does not reckon an action to be in compliance of an order in letter and spirit. Now, your lordships were considering the situation which had traversed from 2013 onwards to 2023 and being alive to the situation of post-poll violence in 2021. In 2013, when the Election Commission had gone to the Supreme Court challenging the state government's action, the state government decided to requisition 82,000 paramilitary personnel. Today, my lord, the number of districts has enhanced from 17 to 22 in the state of West Bengal. So is the number of seats. And the tenor of your lordship's order to be complied in letter and spirit is to instill confidence in the electorate. And the requisitioned personnel from the central paramilitary forces is 1,700.
We read somewhere in the newspapers that 22 companies have been
But one company is 80 personnel, active personnel with 10 reserves. 10 reserves meaning thereby cooking personnel, doctors, not some staff, drivers, all these things. So 80 active personnel in a company. One company consists of 80 active personnel. There are 22 districts in the state of West Bengal. Now, today, in contempt jurisdiction, your lordships are not only concerned about enforcement of the orders, but my lord, I need not cite any judgment before your lordship that contempt jurisdiction also extends to retributive justice being extended.
even curative.
That's the remedial measure that the court can grant by way of relief in contempt jurisdiction. Now, today, if by way of show of a compliance, your lordship's court is once again tried to be hoodwinked. Not I am carefully and consciously choosing this expression hoodwinked. I know I am before the highest authority of judiciary in the state of West Bengal and before the highest court of law in the state of West Bengal. But your lordship's court is repeatedly being sought to be hoodwinked by such action of the Election Commission, which renders justice to be nugatory and the faith of the public in the system to be rendered null and void. This was not the purpose for which your lordships directed the Election Commission to requisition paramilitary forces. $75,000 booths. Not let us know and not please. This was part of SLP by the state election commission. This was part of the SLP of State Election Commission. The argument was advanced before your lordships on the 15th of June 2023 that the state had requisitioned from other states.
Yes.
So far as police forces are concerned, state police forces are concerned. 12th of June 2023, this letter was written. We didn't have any knowledge till such time this was disclosed in the SLP. Subject is requirement of additional forces for forthcoming Panchayat General Elections 2023 in West Bengal to be held on 8th of July 2023. This is to inform that the Panchayat General Elections in West Bengal have been announced and these are scheduled to be held on 8th July 2023 to ensure adequate deployment of police force in order to conduct the elections peacefully and to maintain law and order and to conduct the elections in a free and fair manner. It is requested that the government of Punjab may please arrange to provide police force from Punjab Police for the purpose the forces, these forces may reach the designated locations by 6th July 2023 morning.
No, in which order we recorded the submission, the 3 or 4 states?
Yes, no, that's the second order of
First
15
order
June.
or second order?
15 June, that's at page page 33. Paragraph 6, page 33. As could be seen from the decision of so and so, dated 13 June 23, the court was of opinion that requisition of central forces would aid and assist in the conduct of free and fair election. The court also noted submissions of the petitioners that there was inadequacy in the police force. It is submitted by learned senior advocate appearing for the state of West Bengal that police force have been requisitioned from other states and sufficient number of police will be made available. In our view, it is not clear as to why the State Commission and the state of West Bengal are averse to deployment of central forces when on earlier occasions such deployment has yielded the necessary result. Thus, even assuming the police forces have been requisitioned from the neighboring states, in our opinion, the same will not solve the issue and the assistance of the central forces is vitally required as the methodology that will be adopted by such central forces are quite distinct and such presence and assistance of the central forces have yielded results earlier. Therefore, this court is at a loss to understand as to why the State Election Commission is yet to identify the sensitive districts in spite of several news reports reporting violence in several areas, whereby the candidates who were desirous of filing nominations were prevented from doing so. There is also allegation that civic volunteers have been given police uniform, but I need not. Therefore, if any attempt is made by any authority to make the said order unworkable, will be liable for action under the Contempt of Courts Act. In any event, the state should ensure that the officers and employees of the state who are deployed for election duty should carry a valid identity card. We accepted this on good faith that on 12th June 2023, some action might have been taken by the state authorities, which prompted the Learned Council to make this submission on 13th of June before your lordships. And what we find from the 12th June communication is on 8th July is the scheduled date of election. And 6th July, the force will be deployed from outside states. And please see the tenor of the 12th June letter. Number of police personnel required, their transport, logistics, etc. may be worked out by the Director General Police Punjab with the Director General Police West Bengal. So and so will be the nodal officer for the purpose. 12th of June 20, that's the impression given to the court. Not giving a wrong impression is also contemptuous. Not had your lordships.
I think in the first order, the names of the 4 states were mentioned.
Yes.
Where is the first order? It's not here. Now, what is the present position?
As of today, your lordships are pleased to find that there is requisition of unidentified number of police forces from 4 or 5 states, which are to be deployed on and from 6th of July 2023, the date of polling being 8th of July 2023. This is number 1. We have come to know that roughly 1700 central paramilitary forces have been requisitioned.
1700.
1700, roughly. For 22 districts, 1 company may be for 1 district, and 1 company comprises of 80 active personnel. Is on 8th July, don't confuse. Today, the spirit of the order was not only for the purpose of the polling day.
No, it is to cover the entire election.
Entire elections.
That was clear. That is why the first order was passed even well before the last date of nominations had to expire.
And what your lordship's apprehension as not expressed in page 42 of the contempt application. And it was paragraph 16 of your Lordship's order, which the Honorable Supreme Court has also taken note of. Note it begins at page 41, paragraph 16. In the light of the observations in the preceding paragraphs and also taking note of the fact that no appreciable steps have been taken ever since the order was passed in the earlier writ petitions and till date, no effective steps have been taken to identify sensitive areas from law and order point of view. And in the light of the submission on behalf of the Commission that it may take a couple of more days to do so, we are of the view that waiting any longer will cause more damage to the situation and will not aid in protecting the purity of the election process. But 8 more persons have died in the meantime. It's common knowledge after this order on 16th. Now that's the hard and brutal reality. Nobody can deny, no affidavit is necessary. And what can be more supreme than right to life of the electorates? That's the most paramount consideration in the constitutional framework. That's the most effective, most paramount, and the most supreme fundamental right available to a citizen qua an electorate. And that's what your Lordships wanted to protect.
We'll hear the Election Commission.
Just to show that not on the earlier occasion, not the what was the scenario?
2013.
That was the 2013 scenario. And not that 12th January 2023 later not is a complete and not express indication of mind of the Election Commission. Please have a look at not the second page of the order. Paragraph 3. It's reported in
State Election Commission went up in appeal.
that was really one of the rarest of rare occasions where the West Bengal State Election Commission as an independent body challenged the decision of the state and went before the Honorable Supreme Court for deployment of paramilitary forces. Paragraph 3. We have heard learned senior counsel for the West Bengal State Election Commission, the learned senior counsel for the state of West Bengal, and the learned additional solicitor general for the Union of India. And considering the fact that it may not be possible to deploy the forces by the 2nd of July, we have now rescheduled the elections in 5 phases. That was a 5-phase election to be held from 11th to 25th July. The reschedule of the elections and the deployment of forces by the state and the union as well as the districts in which the elections will be held in 5 phases are given hereunder. Not there were 16 districts at that point of time. And please have a look at the extreme right-hand column. That's the number of personnel in the Union of India forces. The middle portion is the state forces. The last column is the central forces. Not as against 1,05,000 state police forces, there were 82,000 central paramilitary forces or central forces.
1,05,000.
1,05,000 was the state police force.
Yes.
And there were 82,000. Not 82. 92,000.
No.
I'm sorry. 82,000.
And then the state was 17 only.
With 16 districts or 17 districts. I'm sorry, 17 districts.
One phase by studies.
And that was a 5-phase election.
5-phase election.
Yes.
5-phase election in 17 districts, 1,05,000 police forces, 82,000 central forces.
All right, we'll hear the commission.
1,000 companies, that is.
Yes, sir. Page 36. In page 36, we have mentioned the districts, states from which they wanted to. Further, it is reiterated that already police force have been requisitioned from the state of Orissa, Jharkhand, Bihar, Punjab, and Tamil Nadu. Page 36.
Yes, I'm grateful. These are the 5 states.
Hardship was pointed out.
Your lordships were persuaded to observe this apropos the
Because
submission
they made the submissions.
advance that we had already requisition, but we did not know that the requisition was for 6th of July.
So no area domination, no confidence building.
Yes, sir.
My lord, after your lordship's order, my lord, after the Supreme Court, my lord, was pleased to, my lord, uphold your lordship's order. My lord, on the same day, my lord, immediately, my lord, the Election Commission wrote to the Home Secretary of the Government of India, asking for deployment of forces, and my lord, not, my lord, with any delay. And my lord, communications were also made to all the district magistrates of all the districts. Now, my lord, it is true that, my lord, as of now, my lord, for each district, my lord, there has been, my lord, one company that has been sought to be deployed. But, my lord, here, if your lordships direct, my lord, that further forces should be sought, my lord,
No,
immediately.
sir. We fail to understand. It's
No,
a
well,
very
I
no, it's a very, we are on, what is it, live streaming. It's a very sorry state of affairs. Any aggrieved person by any order is entitled to file an appeal. But right from the beginning, what we have been trying to emphasize is that you are a neutral body.
Yes.
Right from day one.
Yes, ma'am.
When the submissions were made, you are a neutral body and you need not toe the line of anybody. You need not walk the dotted lines. So therefore, is it the court to advise the commission whether 1,700 people will be sufficient or 80,000 people would be sufficient or 8 lakh people would be sufficient? It is for you to make the assessment. That is why in this order we said they may have an assessment plan, but the ultimate decision, that's the word we used in the order, the ultimate decision shall lie with the commission. So when the court reposes such confidence, it belied, it did not. It did not act as per the confidence reposed by the court in the first order. This necessitated the second order. And now the present conduct of requisition, if what Mr. Mazmundar says is right, 1,700 people for 32 districts or 22 districts is highly inadequate. Highly inadequate. And we were not shown this order earlier. We were not shown this order earlier. Very interestingly, it's a 5-phase election, which was manageable. Now 3-tier conducted on same day, 75,000 etc. Seats to be done. So many polling booths, and it's scattered. It's not like in a city to travel in one place to another. Even at that time, for these days, 82,000 people, 105,000 was the state strength. Now let us assume, but these people are from the neighboring states, will reach on 6th. For them to get acclimatized, it will take at least half a day. Then you will have to, where to deploy them, mode of transport, etc. So effectively, they will be reaching the venue only on the 7th mid-noon. And the heat is the election. Preparedness, the DM, how to interact with the local police, the central forces, so much a problem. And probably requisitioning these forces from these states like Orissa, Jharkhand, Bihar, Punjab may not be a problem with regard to language. With regard to the state where I come from, language will be a barrier. So unless there is a high-level officer or couple of officers accompanying the battalion, they will not be able to translate the whatever orders you. So if the court shouldn't lose faith in the system. And ultimately, if the people start losing faith in the system, what's the purpose of conducting the elections? And we didn't know that it was elaborate order passed by the Hon'ble Supreme Court. We were also reading the press reports only just now we saw. And the Hon'ble Supreme Court has extracted both the orders 9-6 and 13-6. So at least speaking for myself,
well, the orders are very clear.
What do you say? Should we doubt the independence of the commission? That shouldn't be a sin. That shouldn't be. That is why in the first instance itself we said, please read a T in session judgment. What is the powers? So let us be frank. You have gone to the highest court. The court has given some directions, approved the directions. Rightfully, accept the judgment. Do what is needful. Let us not toe the line. If it is very difficult for the commissioner to take orders, he can step down. Probably His Excellency the Governor may appoint somebody else in his presence. Because that's a very, very important post. Very important post. And the tenure is short, of course, till the declaration of result, etc. It won't take much time for us to say, etc., etc., issue notice of contempt. There has been it. What does it mean? We expected today, we were discussing that there are chances that the contempt application will be withdrawn.
Lord, kindly allow me to have just 1 minute's time to take instructions here and now.
But I don't know, sir, who's present. Even last hearing also, when Mr. Mitro appeared, there was nobody. Other time when Madam Sinha appeared also, there is nobody responsible from the commission. Very unfortunate. Very unfortunate. Even in small revenue matters, officers, especially we find that that CSE, that one officer, she is always present in court. And if the commission is so busy, can't instruct the senior counsel, can't instruct, they better wind up their business.
Kindly give me just 1 moment's time, my lord. I'm
Sir,
very
if
embarrassed.
Suppose they feel that no, they are not in a position to, please leave it to us, we will handle it.
Kindly give me just a moment.
Please.
But in view of not the conduct so far expressed by the commissioner. I'm sorry.
You want the election commission to, you want the court to pass an order to destroy 18,000. My lord, the instruction is, my lord, we had asked for deployment of, my lord, 22, my lord, 22 companies. But, my lord, we have also independently, my lord, deployed 6 companies of specialized forces for, my lord, my lord, 6 sensitive districts. But, my lord, after that, my lord, my instruction is whatever, my lord, the court feels will be adequate, we will immediately send a requisition to the, my lord, central forces. No, my lord, I leave it because, my lord, today,
Be a situation, one Jawan for one citizen.
well, the difficulty is, my lord.
And the court made it clear in 2 orders that no part of it should be charged to the state.
That's right. That's right.
That can be, I don't know if you are still not satisfied. Please come. This contempt application has been filed alleging willful disobedience of the order and direction passed by this court in WPAP 301 of 2023. There was an earlier order passed by this court in WPAP 250 of 2023 dated 13/6/2023. In the order dated 15/6/2023, there was a specific direction issued to the State Election Commission to requisition the deployment of central forces for all districts in the state of West Bengal, and the direction was to be complied with within 48 hours. And in turn, the central government, on receipt of such requisition, to deploy the required number of central forces and the cost to be borne by the central government, and no part of it to be charged to the government of West Bengal. The State Election Commission, as well as the state of West Bengal, had filed specially petitions before the Honorable Supreme Court against both the orders passed by this court, that is dated 13/6/2023 and 15/6/2023. The Honorable Supreme Court, by an elaborate order, had dismissed the special petitions. The operative portion of the order reads as follows. Sir, Supreme Court order, page 11. Page 11. Till the end. The Honorable Supreme Court, after taking note of the observations and findings recorded by this court in both the orders, pointed out that it is needless to observe that the central forces would act in an appropriate manner, bearing in mind the emerging situations and for aiding in a free and fair conduct of election in the state. Further, the Honorable Supreme Court pointed out that democratic nations, Burgeon, B-U-R-G-E-O-N, on the strength of purity and impartiality in elections, and India, being a colossal democracy, demands such a process. In this regard, the Honorable Supreme Court referred to the observations of the Constitution Bench in T.N. Session versus Union of India, 1995, 4 SEC 611, and Srimati Indira Nehru Gandhi versus Rajnarayan, 1975, Supplementary SEC, page 1. Further, it was pointed out that the sentiment that free and fair elections are at the heart of democracy has been echoed by the Honorable Supreme Court in several judgments. Thus, the issue would be whether the order and direction issued by this court, as affirmed by the Honorable Supreme Court, has been complied with. After hearing the arguments of the learned advocate appearing for the petitioner and the learned senior advocate appearing for the State Election Commission, we have no hesitation in our mind to hold that the order and direction has not been complied with in its letter and spirit. We fail to understand as to why the State Election Commission is still not taking an independent decision in the matter. And the learned senior counsel appearing for the State Election Commission has instructions to state that the Election Commission will abide by the directions issued by this court. In the first order passed by this court, the court reposed confidence on the State Election Commission and left to it to make an assessment of the sensitive districts. We found that this direction has not been well taken, and the matter was being dragged on, which necessitated the court to issue direction for deployment of central forces for the entire state, which order has been affirmed by the Honorable Supreme Court. We are informed that we are not informed. Strike out there. On instructions, the learned senior advocate from the appearing on behalf of the State Election Commission submitted that one company, inverted commas, of central force has been requisitioned for each of the 22 districts. It is submitted by the learned advocate for the petitioner that one company consists of 80 persons, which would also include persons who are to assist the
80 active personnel.
80 active personnel. 80 active personnel. As remaining sentence is taken. And given the total number of persons, thus the total number of persons, the total number of central force, active central force, which will be in place is around 1,700, which in our view is thoroughly inadequate. We are justified to take such a stand in the light of the decision, in the light of the requisition which was made for deployment of central forces during the elections, panchayat elections conducted in the state of West Bengal during 2013. In this regard, we refer to the decision of the Honorable Supreme Court in West Bengal State Election Commission versus State of West Bengal and others, 2013 SEC Online SC 1283. Full stop. It is interesting to know that the West Bengal State Election Commission was the petitioner before the Honorable Supreme Court, resisting the decision of the state of West Bengal in the matter of deployment of central forces for the 2013 Panchayat election. If that was the manner in which the West Bengal State Election Commission had acted in the year 2013, we are at a loss to understand as to what has happened to the independency and supremacy of the State Election Commission during the ensuing elections. In the said order of the Honorable Supreme Court, it has been recorded that the elections to the 2013 Panchayat elections was to be conducted in 5 phases from 11th to 25th July 2013. And interestingly, the deployment of state police was 1,05,000 and central force was 82,000. And more importantly, at the relevant point of time, there were only 17 districts in the state of West Bengal, as against 22 districts at present. Therefore, if the State Election Commission is not proactive and not inclined to implement the order passed by this court in its letter and spirit, we may be well justified in forming a prima facie opinion that the State Election Commission is attempting to make the order passed by this court unworkable, which they are not entitled to, more particularly when the Honorable Supreme Court has affirmed the order. This will also lead us to a prima facie conclusion that there has been deliberate violation of the order and direction to be complied with in its letter and spirit. However, in the light of the submission made by the learned senior advocate appearing for the State Election Commission, that the Commission will abide by the directions issued by this court, we are inclined to issue the following directions, which are ancillary and supplementary to the order passed in the earlier 2 writ petitions. The State Election Commission shall, within 24 hours, requisition sufficient number of central forces to be deployed to all the districts, and the number of the companies / battalion to be which are to be requisitioned shall be not less than the force which was requisitioned for the 2013 election, and it has to be definitely more than the same, as the number of districts have increased and the electorate would have definitely increased between 2013 and 2023 in these 10 years. Therefore, we expect the State Election Commission to take note of this direction in a proper and effective manner, and the court hopes that the direction will be complied with in its letter and spirit, and any attempt to make the order unworkable may result in adverse consequences. It is pointed out, next one, it is pointed out by the learned advocate for the contempt applicant that in the specially petition filed before the Honorable Supreme Court, the copy of the letter addressed by the Additional Chief Secretary, Home, Hill Affairs Department, Parliamentary Affairs Department, Government of West Bengal, to the Principal Secretary, Department of Home Affairs and Justice, Government of Punjab, dated 12/6/2023, was annexed. On going through the letter, we are surprised to know that the requisition which was made to the Government of Punjab was to provide police force to reach the designated location by 6th July 2023 morning. When the submissions on behalf of the State Election Commission was heard by this court in the writ petition, we were led to believe that already sufficient number of force has been requisitioned from the states of Orissa, Jharkhand, Bihar, Punjab and Tamil Nadu. The court was of the view that such requisition has been made and the force is required to be present till the entire election process is completed. Surprisingly, the instruction given to the learned senior advocate who appeared for the State Election Commission is contrary to what has been written by the Additional Secretary to the Government of West Bengal, to the Principal Secretary, Department of Home Affairs, Government of Punjab, dated 12/6/2023. This also appears to be, this can very well be taken to be an attempt to mislead this court. As the court, even in the order passed in the earlier petition, had made it clear that the requisition of central forces was to cover the entire election process and not on the date of polling alone. Therefore, we are of the clear view that such deployment of the forces from the other states, that too at the for the to be in place, not for the, to be in place on the date of polling will not yield the desired result. Therefore, dehorse the number of police force which have been requisitioned from the other states. The State Election Commission shall independently assess the requirement, and as observed earlier, the assessment should be honest and should be honest, and bearing in mind that the State Election Commission has a constitutional obligation to ensure free and fair election and preserve the purity of the entire election process. We hope and trust this direction be complied with effectively and immediately without loss of time. List the matter on Friday.
Your Lordships may also not consider appointment of an observer for the purpose since action is.
We'll see. That issue we already dealt with in the first term. Next.
We are similarly placed with regard to item number 1. Only additional.
Oh, the composition is different.
Combination is different, my lord. I appreciate that, my lord, but since Lordship has been,
I think this order will cover probably next week.
Only one thing, my lord. Lordship will kindly take, my lord, page 30 of 13th order, my lord.
30,
my lord. Page 30 of the order that has been annexed to the petition, my lord. Para 51, I am relying upon, my lord. It's a longish paragraph, my lord. I need not read out the paragraph. Only thing I would like to point out, Lordship was pleased to allow us as interveners, my lord, in the main writ petition, my lord. We appeared before the Honorable Supreme Court, my lord. Our submissions were also recorded, my lord, and that reflected in the order as well, my lord. Only thing is with regard to videograph and CCTV, my lord. Lordship was repeated.
The commission has already.
No. May I respectfully say this, my lord? No. Some parts, my lord, videography has happened.
What you do is, let senior counsel get instruction on that. You make a request for assigning this matter to this bench.
Oblige, my lord.
You make it.
I will immediately, my lord.
Make it to this, the OSD.
Yes, my
You
lord.
will place it on Friday. We can take it.
Grateful, my lord. We'll just do the
You
needful,
note
my
down, sir. In this contempt application. arises
May a
out
copy
of,
be served on us, my lord?
We have served, Miss Sen.
Order passed on 13/6/2023. However, the composition of the division bench is different, and the learned advocate appearing for the petitioner seeks liberty to move the registry for assigning the matter to this division bench.
Grateful.
This is the matter on Friday.
Along with the first item, my lord. Deeply obliged, my lord.
That's all.